My lord, one indulgence. The petitioner is 85 years old. CPF to GPF only interest area gratuity payment. I mentioned this matter on last November 3rd, but till now not in the list.
I cannot grant any indulgence today.
My lord, 85 years old.
Sorry.
Before his death,
Yes.
want to
Bring your lordship leave to move the requisition on urgent basis. Because my lord, on 6th November, your lordship was pleased to give direction upon the commission, my lord, to allot my lord experience marks to the other petitioners, and they have complied the order. That they are
Other
the
petitioners means?
other petitioner in my other writ petition, my lord.
Yes, but the court never granted
So
any.
consider the case of the petitioner, thereafter they
Consider.
complied. And what has happened, my lord, the petitioner, the present petitioner, my lord, are similarly circumstanced and situated. They serving in the same school. Well, let the matter be listed any day, my lord, that it
But
can
then
be.
why so late?
Well, after getting the information, the notification is published in the website of the commission.
Yes.
That, my lord, the 6 persons are allotted, my lord, additional marks for teaching experience.
So you are a fence sitter. You see others get marks and then you rush to court.
Well, we are not the fence sitter, my lord.
What are
We
you?
are entitled to get the marks, but due to confusion,
Whatever.
my lord, created by the commission in the online portal, my lord, I attach the order also.
Maybe, but then today it cannot be done. Your credential verification is going on.
No.
Is your not yet started? Thursday it will appear. Serve.
Yes.
permitted, my lord, on matter, my lord, CPF to GPF matter.
Yes.
May I have your lordship's kind leave to mention this matter? Your lordship, my lord, the petition item number 49. I thought the matter would be taken up today, but after seeing the instruction,
Yes.
told that matter will not be done. My lord, petitioner applied as an SC candidate, and but after the verification, he was designated as a general candidate. Verification is on foot. Your lordship has already decided the issue. I have the form where I have paid 200, applying as an SC candidate. My lord.
Item 49.
Item 49, fourth is the verification.
I am mentioning for the small.
Alright, it will be upgraded as urgent motion. Tomorrow. Give notice to the commission.
Yes, my lord.
May I have a correction?
What is the correction?
The name is not proper.
Whose name?
Advocate.
Give.
I have my lord's leave for inclusion of this recalling act.
My lord, one matter.
My lord, remember.
No inclusion, please.
My lord,
This
is
urgent,
my
my lord, on the bench, my lord, while my lord
matter
was,
appearing in the.
my lord was sitting in courtroom number 14. My lord, remember there was an lookout circular challenge matter, whereby my lord has directed until and unless the issue is decided before the Supreme Court, matter will be delisted from the list. But what has happened thereafter, my lord, that we have made, I take it upon myself, we have made a small wrong submission before your lordship. We just need to place that fact before your lordship. It will not take than more than 2 minutes, my lord.
Yes, but when can you be accommodated? You see
My lord takes
this.
the application on Thursdays. I'm just seeking for the inclusion only, my lord. It will not take more than 2 minutes. My lord takes application on Thursdays only, my lord.
But then it will be very difficult, sir.
But at least let it
can
be included
done.
whenever it's convenient to your lordship, my lord. It will be taken up, but let it be included. That's my only humble
I
prayer
am
to your
not
lordship.
permitting inclusion this month. Entire month
I'm just seeking for inclusion of the application, my not the writ
I
petition, my lord. But because the
understand.
determination is before my lord Justice Rao right now.
So why don't you go and get
And
things done today?
I'm seeking recalling of my lord's order. That's I have to be before your lordship.
Recalling, apart from recalling, if you can proceed with the main writ petition and get it
And
disposed of.
until unless I recall that particular portion, until unless I pray for recall that particular portion in my lord's order, I cannot proceed with the main writ petition.
It doesn't matter. Next month I'll see this one. Excuse, please.
Great.
Oh, yesterday why didn't you give the number?
My lord, my matter has been fixed today. Yesterday matter in the monthly list 16343 item. Today is not in the list.
It will appear in the list. Do not worry. If you have mentioned, it will appear.
Today is
Please.
fixed, my lord.
Who has fixed it?
Your lordship has fixed the matter today.
What is the urgency?
My client is not getting his pension and your suspension allowance, anything else, my lord.
Please wait. What is the item?
Item number 2, yesterday list 1643.
দেখুন তো mention হয়েছিল কিনা?
Mention.
Please check whether it was mentioned or not.
It was highlighted that 212.
All right, please wait.
My lord, I'm sending one matter for upgradation, pension matter.
Sorry, sir.
My
Is it there in the list? Then give the number.
My lord, one matter CPF to GPA matter upgradation.
Since when are you
Matter in
practicing?
the appearing in the.
Since when are you practicing here? Since when are you practicing? Tell me, since when are you practicing? Are you aware as to how the matters are mentioned? Somebody is mentioning and you jump inside. There will be no inclusion. Yes.
I'm mentioning upon notice, the only thing is my pension and gratuity has been withheld because a criminal proceeding is pending against me. Now, a few days back, the issue has been clarified that under DCRB rules, pension can be withheld till the completion of the criminal proceeding, but not the gratuity. Our honorable division bench has held it. I'm only praying the matter to be included in the list so that.
Inclusion?
Yes.
Sorry.
I'm suffering for 2023. Your
I'm
lordship.
sorry. Yes.
The monthly, sir, January of.
Next month, please come.
Any show-cause notice or any,
I do not want to hear the merits.
this is for inclusion, my lord. Why?
No mentioning for inclusion, please. Sorry. Yes.
No salary at all, my lord.
No, nothing doing. Yes. What is the correction? Why did you not make the correction? When you handed over the draft copy, it was not corrected.
I don't know why the advocate could not get correction. But the notice is I have corrected from there. That's why no, I have.
What is the correction to be made?
First, here, thereafter die. Therefore, the pension will be calculated from the return. Go down the initial or first.
It is mentioned the area of pension. Yes.
Pension and immediate pension.
No, it is family pension. It is mentioned area pension will be given and family pension will be released from the date of death. So it is all right. I do not find any error. You are interpreting it in your own way. Sorry.
Lordship,
Yes.
may I allow to mention one matter? Lordship, on last occasion, I have came to mention this matter under inclusion. So your Lordship was directed me to come in this week. So that
In
just
this week.
in this week, Lordship, on last Thursday.
In
I
this
was-
week, yesterday, all I have accepted mentioning. It cannot be done every day. It cannot be done every day. Yes.
My lord, may I kindly have your kind attention? My lord, I mentioned it for non-prosecution, but it has appeared in the list under the heading of motion.
All right. Give non-prosecution.
But may I be permitted to grant leave to move this matter, my lord? Full Service Commission, this issue has not yet been raised. There are, my lord, directions from this court that the tainted candidates, the list should be published. These candidates say, my lord, to publish a list which does not have expiry of panel, which does not have rank jumping, which does not have anything. My lord,
Even
OMR.
for the teachers.
Yes, yes, my lord, 2000, because
But then the teachers list has been published, isn't it?
no, my lord, the candidates other than expiry of panel, rank jump, OMR, all type of dispute, leaving all those candidates, my lord, all those parts, the candidates who are not specifically tainted, my lord, this list has never been published. And my lord,
Not
have to read.
specifically tainted. See, if the candidates who have OMR mismatch and all these illegalities are given, then the others will be not
my lord,
specifically
the
tainted.
fact remains, my lord, there is a direction by the Supreme Court as well as the division bench for recovery of money. So, my lord,
Yes.
that must be specified who are not entitled to refund their salaries. This is also one part is there in this. That is why, my lord, the same thing, this will be there, this list also be there. Other prayers are there, but this is the fundamental prayer, my lord, which the petition.
Other prayers means what prayers?
Other
Are you
prayer means
challenging?
publication of the OMRs and all, my lord, this type. I am not challenging the rules or anything, only
Nothing.
publication of the list. my
All
lord.
right, then there is not so much of a hurry. Then next week I can keep it.
Yes, next video, lordship may keep it.
Very well. Second, next Tuesday, 9th. Urgent motion.
Well, these matters are identical in nature. Well, these pertains to question dispute in second SLST, my lord. These matters were running in lordship's daily list, my lord. Now in the monthlies, it has gone very much down, my lord. These petitioners are just shortfall 1 or 2 marks. And my challenge is that, my lord, the question were made from out of syllabus, my lord. My lord, all the identical matters, some of the issue has already been raised before your lordship, my lord. Your lordship called for a report, my lord. My lord, if this can be taken up, my lord, since the verification process is going on.
Day after tomorrow. Third notice, the commission should be put on notice.
Applies.
Item number one, for updation 1143, Lordship.
Why?
The matter is relating to compassionate appointment, Lordship. Representation already made to the DI, DI not been sitting tight over the matter 2020.
Give the number, urgent motion. Third notice upon your other side.
My lord, item number 1599, matter is relating to the interview post of assistant headmaster. I am the first in panel. Thereafter, when a second is objected by DI, DI will be stopped.
I did not follow.
Post of assistant,
Yes,
I am the panel in first.
yes.
Okay. Thereafter, second is objected by the DI, DI will stop the interview.
DI has stopped the interview panel. Yes. So what is to be done?
I am the urgency, upgradation, my lord, 1599.
No, I'm not upgrading. Yes.
And may I permit to mention for upgradation
Oh, sorry, don't
matter, my lord.
don't mention.
My lord, may I permit to mention a matter for inclusion in the list?
No inclusions. I am refusing. Why are you coming? Yes, madam.
Your Lordship, there has been a dismiss for default order in a matter on 17th September 2024. A restoration application was also filed. Thereafter, it was kept for hearing, but the matter did not appear in the list. If kindly this matter would be included in the list and be
So
heard.
you want inclusion? I am not permitting inclusion this month.
My lord,
Yes,
my lord.
second matter. I am not,
I'm not seeing anything.
My lord,
First retirement.
Correction.
Kindly see
Correction is
one time.
correction.
What is the correction?
Correction is the only date, month and year. Date of
Date,
retirement.
month and year of the
Also date
order.
of retirement. Date of retirement.
All right, give.
Not the petition.
Well, another matter is restoration application. my lord.
No inclusion.
Lordship, may I permit to
The
mention?
petitioner, my lord, is not receiving salary, my lord. And
Yes.
it has been taken up by the earlier coordinate and directed to appear, my lord, on 10th of November. That is why I was praying for inclusion, my lord.
I am not including. Please excuse.
Lordship, may I permit to mention one matter, Lordship? One contempt matter, Lordship. For inclusion, Lordship.
No
Lordship has
inclusion. Call the list, please.
contempt matter, Lordship.
Why?
Acted melody. Retired teacher concerned, retired month before the notification. Subsequently died.
Yes.
Is entitled to receive arrear melody from the date of retirement. Next date of retirement, not from the date of death.
It has been
Died in
mentioned.
unescant.
It is mentioned that the family pension will be given after on and from the date of death. Read the order.
No.
This is what he has shown me. The next page.
It is not the family pension.
This is he showed me that portion.
11, character 11.
There is a tick mark. Family pension from the date of death. Obviously, family pension will be from the date of death.
Arrear pension and family, yes. Arrear pension from the retirement, family pension from the date of death. ঠিক আছে, ঠিক আছে।
My lord, I am appearing for the petitioner, my lord. On last occasion, there was a direction for filing supplementary affidavit. I am filing supplementary affidavit. My lord, order was for consider of representation within 3 months after giving reasonable opportunity to all the party concerned. That has been not done by the respondent bank. My lord, thereafter contempt notice was issued. After receiving the contempt notice was issued, they have given a letter wherein they are now asking for a succession certificate in respect of a immovable property. There is a well settled law, my lord, where a succession certificate is not required for immovable property, my lord.
But don't you, where is that order?
Well, my lord.
They want succession certificate.
Page number 37, my lord. My lord, in supplementary affidavit, page number 8. Last portion, in view of this, we request you to submit a court-issued succession certificate supporting the claim by legal heirs for registration of sale certificate.
Right.
Yes.
So if this is a fresh communication that has been made in compliance of the court's order, then this is a fresh cause of action.
My
How
lord,
can it be looked
first-
into in a contempt?
My lord, firstly, they have asked for a legal heirship certificate. Then they have asked for a first-class magistrate
So it is a
certificate.
very good ground to file a fresh writ petition. What can be done in the
My lord, we are
contempt?
roaming for 5 years with the bank, my
It
lord.
cannot be done. Please come.
Well, only they are harassing, my lord. We
The
are asking
petitioner
for a registration of sale
is aggrieved
certificate
by
in
the
the
communication dated 15th October 2025, issued by the authorized officer / chief manager of the bank, requesting the petitioner to submit a court issued succession certificate supporting the claim by legal heirs for registration of sale certificate. The petitioner is aggrieved by the same. It has been alleged that the said direction has been passed contrary to the direction passed by the court on 1st July 2025 in the writ petition.
They have
Stop.
not given a reasonable opportunity, my lord. They have not asked for hearing. There is a specific direction. We have submitted all documents which they have required. And after filing writ petition, they did not appear before this court, my lord. And in their absence, that order was passed. And when 3 months has been lapsed, they have now again requesting a fresh document. I am asking only for, my lord, registration of sale certificate. And we are ready to pay stamp duty and registration charges.
কি বললাম? To the direction, ঠিক আছে, লিখুন. Right. On a perusal of the order dated 1st July 25, it appears that the senior manager of the Indian Bank, being the respondent number 3, was directed to take steps to consider and dispose of the representation made on behalf of the petitioners within a after giving a reasonable opportunity of hearing to the petitioners and all other necessary parties within a stipulated time period. Stop. The time period to comply the order passed by the court has expired. Stop. The petitioner alleges that no opportunity of hearing was given prior to passing the impugned communication dated 15th October 2025. Stop. Sir, your contempt application is not in form. Who is the contemptor?
Contempt is senior manager, my lord.
In a contempt, you are required to implead the person by name and not by designation, against whom the rule will be issued.
My lord, this person is charged. It may be to change from time to time, my lord, senior manager.
You need to know as to how contempt petitions are drafted, how they are prepared, how it is moved. Your contempt is liable to be dismissed. Your application is not in form.
What will be given to correct that?
On a perusal of the application for contempt, it appears that the same is not in proper form. The contemptor has not been impleaded by name. Stop. The court is not inclined to exercise jurisdiction in the contempt matter. Stop. it will be open for the petitioner to challenge the impugned communication dated 15th October 2025 in accordance with law before the competent forum, if so advised. Contempt disposed.
Diploma.
None appears on behalf of the petitioners. No accommodation sought for. The writ petition stands dismissed for default.
Item 9, I appear for the petition.
Lordship, Mr. Dinda is appearing for the state, Lordship.
Who is appearing?
Mr. Dinda, Lordship.
Yes.
Lordship, due to personal difficulties, Mr. Dinda cannot attend court, Lordship. So paying for not today.
That state has no role to play. I'm an unapproved teacher of a DA grading school. The charge sheet is under challenge issued by the school. Till I'm approved and I'm getting DMLed, state has no role to play. That Mr. Body is there for the school. Your Lordship, so please, I can place.
Madam, may I submit one thing? The issue first, Madam, the integrity point was raised. Madam, the one single judge is of the view it is maintainable. Another coordinate bench is of the view it is not maintainable. Tomorrow is the date before the revision bench. Only the score of the maintainability of the writ petition. So, let it be adjourned for a
Alright. Please
Give me
start.
one second time. Madam, give me 1 second time. Please, please.
The petitioner.
Kindly give me
I'll
1
just
second.
adjourn.
No,
There's
no,
a
no.
request for adjournment.
Well, if this is the point of maintainability, the order of
the-
Justice Shogata Bhattacharya was tested
Um,
before the revision bench.
All right. It has been submitted. Let us see. The petitioner is an unapproved teacher of a DA getting school. He seeks certain relief against the school. Stop. The learned advocate representing the school raises an issue with regard to the maintainability of the writ petition at the instance of the petitioner. Stop. It has been submitted by the learned advocate for the school that the issue is presently pending consideration before the Honorable Division Bench, and the same is likely to be taken up for consideration by the court shortly. Stop. Paragraph. A prayer for adjournment has been made on behalf of the learned advocate representing the state respondents. Stop. In view of such submission, release the matter for further consideration on how long?
Now, tomorrow is the date. Let it be for the
15th.
2 weeks.
15th.
Well, may I have the privilege to must say one thing?
No, no.
Well, sure.
Say next two things.
Very well, very well. Great.
The matter in which I was addressing my lord for quite some time. My lord, today, my lord, the contempt application is appearing before my lord. They are supposed to give us something, my lord, which according to us they have not given. They may say they have given, my lord, a one-page document. I'm only praying for one indulgence from this court. There is an order of, my lord, 31st July, which says, my lord, the writ petition and the contempt to appear together. Thereafter, my lord, it was appearing together. Due to, my lord, certain reasons which is beyond our control, the writ petition is not appearing. May I only pray for?
The writ petition will appear before the
That's the reason, madam. My prayer, my lord, kindly consider this. My learned friend may say, my lord has heard the writ petition substantially. I am praying for one indulgence only, that kindly accommodate me for a period of 10 days or 12 days, whatever comments to my lord. We will take some steps, my lord. If it can be taken up by one honorable judge, my lord, it will reduce one multiplicity of judicial proceedings, next, my lord, conflict of judgment. This is the only prayer. And I don't think my learned friend will oppose.
No, I have no.
Is any response from you awaiting? I can see in the last order it's recorded.
Response, my lord, they have not
I have-
given,
My lord,
they have
let-
given a
let-
letter,
let me
they have given a letter, we have.
we have already served later,
November, you filed a composite reply
my lord.
and a response from you.
Yeah, my lord, we have already sent it to, that is duly received by them, your lordship.
That is sent on 20th. We have given a reply to that also on first. I have filed, have prepared a supplementary affidavit, my lord.
How many supplementary will come
Because-
and every
because my lord,
communication
Copy has
will
not
be
been
put
served.
on
served,
record.
my lord, served on them.
No, no,
My lord, I want
not
to,
received,
they
your
are
lord.
taken a point, my lord, with that something is written unauthorized. I have clarified that state government has to
Copy
say
has
unauthorized,
not-
because if they say unauthorized, they charge
যেটা বলবেন,
800.
supplementary
If they say authorized, they
সেটা
charge
বলবেন
400. So that document I could not produce because their only contention is your document says unauthorized. Now I have shown 7 documents of the same month of November where on the basis of unauthorized letter, word unauthorized, they have given recs. So one of that documents I want to bring, but today my lord, I'm humbly praying because all.
That I can adjourn.
Yes.
But then I do not know what to do in this contempt.
No,
The
that's why my,
authority is
my lord, that's why I'm praying, my lord, if the honorable.
very well, please come.
My lord, one indulgence, this copy has not been served upon us.
I will serve today itself.
My-
I will serve,
my lord,
and I will okay, I will serve by tomorrow.
Deeply, deeply great. Thank you.
Tomorrow.
Thank you.
Thank
Good.
Learned Senior Counsel representing the petitioners seeks adjournment. Step in view of such submission, release the matter for further consideration on 16th of December.
Deeply grateful.
And one supplementary affidavit, I will serve a copy by tomorrow. Well, can you, I will
Again,
pray.
supplementary, I am not granting any leave. You see what is to be done.
But otherwise, I will not be able to produce those documents to show, my lord, Article 14 is being breached. That's the reason I'm praying for this, so that he may also be ready. That's the reason.
The petitioners seek leave to file a further supplementary affidavit. Stop. It has been submitted that the documents to be relied upon by the petitioner will be annexed in the supplementary affidavit. Stop. Next. Let such supplementary be prepared and circulated prior to the adjourned date.
My lord, kindly leave be granted to file just opposition, that supplementary affidavit, your lordship.
The writ petition was something, and from there supplementary. The main matter goes.
My lord.
But some matters, my lord, we are only bringing unimpeachable documents before this court for consideration.
Whatever, but then
Kindly leave be granted, my lord.
this document which arises subsequent to the filing of the writ petition, how can those things be considered?
Because, my lord,
Is
because
a
that kindly
question mark.
consider, yes, that's the point, my lord may definitely consider. But on 7, my lord is fixing it on 17th, my lord.
16th.
16th.
Fortnight.
Fortnight.
You want 17th? I can
So-
place it on 17th. 17th.
Deeply grateful.
17th.
Deeply.
If you want to file,
I will.
My lord, my lord, deeply grateful, your lord.
It will be open for the respondents to file exception to the supplementary.
Deeply appreciated.
Deeply grateful, your lord.
Affidavit to be filed by the petitioner. Yes. Uh-huh. For 1644,
44, my
it
lord.
is there mentioned as second. It is there in the combined list. Who is your other side?
State is the other side and
Where? Who is your other side? Bring him at 115.
115.
Yes, bring him.
Okay, thank
Item 1.
This is a correction, my lord, of your lordship's order dated 19th November 2025. Para 1 to 3 will be
Paragraph 1 to 3?
1 to 3.
Yes.
Covered by the Centralized model judge. Now the 4, 5, 6, 7, and 8, and 9. 9 and 10. It would be deleted. It is not been applicable. I have already corrected that order city or lordship, if your lordship peruse this. Look. Yes. Corrected order. Oh.
You tell me whether your father deposited the money, refunded the employer's share.
Yes, yes.
Your father refunded?
Yes, PPO has been issued. PPO has also been issued. 2015. Amount has been paid 4,64,544 on 22nd.
Yes, so what is your prayer?
My prayer is the that is there. It's some sort of to issue the revised pension payment order and release the arrear amount from the next date of retirement to till the date of deposit of the CPF amount along with the interest at the rate of 12% interest of the honorable full bench judgment.
Along with interest. Interest issue is pending before the division bench. Along with
That is
interest.
only-
You have mentioned along with interest.
Only for revised pensions payment order be issued. Because the son is entered. And father died in 2000. Father died in 2024, 22nd January.
From when was the money paid in favor of the father?
Father died in 2024.
Father died in 24,
Mal.
right?
Mal.
The teacher, father was the teacher, he refunded the amount.
Refund prior to that, 22nd September 2015, 14th.
He refunded the amount.
4,64,544.
He refunded.
Yes.
Now what happened? PPO issued.
Thereafter, the PPO has been issued.
Right. From when?
15.
From when?
On 25th June 2015.
And you see the list of
Pradeep. অর্ডার আছে যেখানে টাকাটা রিফান্ড করেছিল দি এমপ্লয়ি, হ্যাঁ, আর পিপিও Let me see. কি দেখা যাচ্ছে?
Justice Basu, coordinate bills.
না, দেখলে হবে না। আমাদের আছে প্রচুর অর্ডার আছে। শীতলা মন্ডলের জাজমেন্টে কভার্ড। এখানে ওটাই চেয়েছে, পেমেন্ট টু বি মেড অন এন্ড ফ্রম দি নেক্সট ডেট অফ
Virtual hয়নি।
এইভাবে দিয়েছিল, ডিলিট করে। এবার
মানে
ওটা তাহলে লিখতে হবে, দি অর্ডার হ্যাজ বিন রংলি এই অর্ডার কিন্তু বাইরে থাকবে, পরে কি হবে?
Petition is not willing to pursue this lead application.
All
Then
right.
the lead application will be treated to withdrawn and it may be disposed of, my lord.
Yes.
My lord, I am appearing.
Dismissed as not pressed.
Instead of dismissal, it should be disposed of, my lord.
You are not pressing it, so what remains?
My lord, on the last occasion, my lord, I took time, my lord. I can it be your lordship, my lord. My lord, there is a Mr. Roy was holding the
That means you are not for the petitioner. Petitioner is.
my lord, Mr. Shamil Badi is the court. School authority, I am for.
My lord, I have not, as well, I was appearing on behalf of the petitioner, my lord.
No, no.
Till
School
date,
authority.
school authority, my lord. Till today, my lord, I have no instruction to issuance of no objection. Just prior to reaching your lordship's court, my lord, my learned brother intimate me that the school authority wants to take no objection from me, my lord. My lord, so kindly adjourn the matter for 7 days, my lord. In the meantime, if my lord I receives any letter from the school authority, I shall issue the no objection.
That was the
Take out all these things. I'll just make it not this.
my lord, my lord.
It's between y'all, please.
My lord, my lord. Grateful, grateful to you.
Appeal of the petitioner in this matter, your lordship has already considered this issue. It is regarding conversion from scheduled caste to general. That I applied as a scheduled caste candidate, but when it came as general. My lordship has already considered this issue in Somnath Pramanik's matter.
My lord, I am appearing for the School Service Commission, my lord.
Yes.
Your lordship has considered and held that once it has been applied as scheduled caste, it cannot be converted to general.
Yes.
The lordship's observation, the relevant portion, my lord, starting from paragraph 21 itself. Lordship has considered. Now I show to your lordship that I applied as an SC candidate. Lordship, kindly come to. First, my lord, I am an untainted candidate. Kindly come to page 632 first.
30?
32. That I was previously I was appointed as a SC candidate itself. Kindly see, my lord, the vacancy.
Yes, vacancy category.
That was previously. That I'm showing that I all along I was SC. My SC certificate is also annexed at page number 29, my lord. That is my SC certificate. Now, my lord, kindly see I applied as SC. That would be evident from page number 36.
Yes.
I paid 200 rupees also. That your lordship has also considered in this Somnath Pramanik's matter. And my lord, page 30 is my receipt, money receipt. Lordship has seen. Now, my lord, kindly see. Admit provisional admit card also page 39, though it is not mentioned, but based on my application, admit card was issued to me. Now, my lord, kindly come to page 40.
General.
Kindly see 518.
Hmm.
I was converted to general. Now, what I try to make out a case, my lord, as per Somnath Pramanik's case, I should be treated as general. Now, my lord, my verification is completed. Now, I'll be treated as, after the subsequent rounds, I'll be treated as SC candidate. Now, the issue is, the problem will arise at the time of counseling. Why? Because, my lord, I am entitled to get the benefit for general category also for securing higher marks on merit, as well as in the SC category. So, my lord, at the time of counseling, I may be given the benefit of both the categories, treating me as an SC category candidate. That is my humble prayer, my lord, covered by your lordship's charter.
Commission.
My lord, in this matter, what has happened, my lord, he has already been come out successfully as a general category candidate. Earlier matter, it was not there. Now, secondly, in his form, he did not fill up that he is a scheduled caste. And kindly see, my lord, that application fees SC, ST, page rupees 200. 3 categories are there. He did not identify. So, my lord, our object is that thereafter option was given. My lord, our object was that not to cancel anybody's application form for this ground. He was allowed to sit in the general class, general category, and he is in the general category. Number 2, my lord, the judgment which has been delivered by your lordships, still it is in force. The point is, let's assume that he is converted in this special caste category. Correct. If we take him as a scheduled caste category, he is an open now. General plus scheduled caste. For scheduled caste only 10, but in general 100 and plus 10. He can choose it. It is very early for him to say that he will not be selected. Nobody knows about that. Thirdly, my lord, I want to make one submission today to your lordship. Even if he is a scheduled caste and he has got the higher number, then he will come into the general category. That is the law. And if that is the law, he will come to the general category. Now he is trying to go back to the scheduled caste category. My lord, the whole purpose of reservation is for the benefits of the scheduled caste community itself, not for individual scheduled caste. If he has got the higher marks, then the scheduled castes and coming under the general category, then he will be another one scheduled caste will get the chance there. If he chooses to remain in the scheduled caste, then another one scheduled caste will loses the chance. So what I am submitting today, your lordships, is this. Kindly keep the matter pending. Let us see his the results of the interview.
Result published. I have participated in the
Result of the final interview. I am talking about final interview. Because he is qualified for the general category itself. It is not that he has not been qualified for the general category.
All right, please come.
My lord, I have a specific response to this. First of all, with due respect to my esteemed learned senior friend, page 36, as it's stated, kindly hear me for once, only once. SC, ST, it was the
petitioner,
dialog box in which I had to apply. There was no specific provision.
participated in the 2025 recruitment process for selection of assistant teachers
I may just make one submission, kindly.
conducted by the West Bengal Central School Service Commission. Stop. She disclosed herself to be a member of the reserved category and paid rupees 200, being the application fee meant for SC/ST and PH.
That is the only option given.
Stop. The petitioner has annexed the annexed documents in support of her candidature in the earlier recruitment process conducted by the Commission in the year 2016, wherein her reservation status as scheduled caste is clearly mentioned. Stop. The petitioner has been successful in the written examination and her name has been published in the preliminary interview list, but under the general category. Stop. She is aggrieved by the same. Stop. It has been submitted that she ought to be provided the benefit of reservation as she is a member of the scheduled caste community. Paragraph. Learned counsel representing the commission opposes the prayer of the petitioner. Stop. It has been submitted that the petitioner did not indicate the particular category of reservation. Stop. She submitted her application fee of 200 rupees, which is meant for the scheduled castes / scheduled tribes and the physically handicapped candidates. Stop. Several opportunities were granted by the commission to update and edit the category option of the candidate. Stop. The petitioner failed to avail the option. Stop. Paragraph. It has been submitted that The petitioner has got marks by which she may be upgraded to the status of a general category candidate. Stop. If she seeks reservation, then another scheduled category candidate will miss the opportunity of reservation. Stop. The benefit of reservation is to be extended to a community as a whole and not to a particular individual. Stop. Prayer has been made to permit the commission to treat the petitioner as a general category candidate. Paragraph.
That is not my prayer.
Whether a reserved category candidate who disclosed the reservation in the application form can be treated as a general category candidate for not updating or editing the option allowed to the candidates has been decided by the court in WPA 26937 of 2025. Decided by the court on 27th November 25 in WPA such and such, Somnath Pramanik Amadir. Stop. The court was of the opinion that once the category of the candidate has been disclosed in the application form, the authority cannot suo motu change such category. Stop. By paying the fees meant for reserved category candidate, the authority cannot treat the said candidate to be a member of the general category for whom the application fee is higher than those of the reserved category. Stop. Paragraph. According to the Constitution, a candidate who is meant to be in a reserved category ought to receive all benefits of the said category. Stop. The candidate may, by her merit, his/her merit, be upgraded to the general category, but the same does not mean that she cannot avail the benefit of reservation. Stop. The reserved category, the community of the reserved category candidates consists of individual members. Stop. The community of reserved category cannot exist without the members of the reserved category. Stop. Since the petitioner has already declared herself to be a member of the scheduled caste category, she ought to be provided all benefit of reservation, including the benefit of counseling, which a reserved category candidate is liable to be provided. Step next. In view of the above, the instant writ petition stands disposed of by directing the commission to treat the candidature of the petitioner as a reserved category candidate in the scheduled caste category. Writ petition.
One line can be, one line can be subject to this. But he will not claim any benefit for the general category.
No, I am entitled for.
No. He will not claim any benefit for
Lordship has recorded that I'll only be treated as SC, my lord, both SC and general.
Yes.
That may be
all
recorded.
Facilities meant for a reserved category candidate will be available to you, which includes that if you prefer a general category seat, by virtue of your marks, you can
that
get it.
be recorded, my lord, since the contention of the commission, your lordship.
That is an absolute incorrect contention, and the court does not feel any requirement of dealing with each and every contention that is raised. Yes, please. Next. Yes.
My lord, petitioner before your lordship is an untented teacher who is permitted to continue his service from 31st December 2025. My lord, this year, my lord, he also appeared. His subject, my lord, Persian PG, case 23. My lord, Persian PG, earlier occasion, my lord, appointment letter, Persian PG. And thereafter, lordship kindly straightway come to page, my lord, 32. Petitioner got out of 60, 56 number. At the bottom, my lord, written exam.
Yes.
56. But unfortunately, that post is vanished. My lord, kindly come to page, my lord, 52. 52, my lord.
No, at the time of application, was any vacancy shown for Persian?
My lord, I permitted to appear in the written examination, but
Show me the vacancy list that has been published that Persian PG had a vacancy.
My lord, thereafter in tentative vacancy is not in the list, my lord, that post, my lord.
Then how did you apply if the post is not?
I am permitted to pay, but according to my lord, Honorable Supreme Court order, your lordship kindly have a look into 17th April 2024 order. 17th April order, already your lordship discussed so many times. There is specifically stated 17th April order and advertisement for press recruitment to the aforesaid post shall be published before 31st May 2025. Aforesaid post, and not only that, the main judgment. My lord,
No,
3rd
one
April
minute,
2025.
1 minute. This is a Supreme Court's order that you read,
My lord,
right?
before
Now the posts were declared by the commission.
Posts were declared by the commission. Now, my lord, post is not in the
31st of May 2025 was the date when the notification was published.
My lord,
was there any vacancy shown in Persian PG?
My lord, that time, my lord, no vacancy.
Then why did you not?
Any subject. Thereafter, tentative vacancy.
When was the tentative vacancy list published?
June 13.
Very well.
Indicative vacancy list.
Right. Was Persian there?
No.
Why did you not approach the court?
My lord, I made a representation then and then tentative. That's why I permitted to appear in the written examination. And not only that, my lord, 3rd April order.
Show me your admit card.
Yes, my lord. (2025) page 31. Page 31.
Yes, page 32. I can see result of the written examination. Subject is Persian PG.
29 first, my lord. Application ID. Mail. Persian PG 29. Medium of vacancy applying Urdu. Complete fees paid. And thereafter, my lord, was the page 31. Yes, my lord, admit card. Provisional admit card for second SLST. Page 31. Persian. Not only that, they cannot change, my lord, with due respect and submitting paragraph 49, my lord, of the main judgment, 3rd April judgment.
No, I followed. Please wait. Let me hear the commission. Commission.
That means Bandyopadhyay is there.
Regarding
Yes,
the
the,
Persian vacancy,
the Persian vacancy.
may I address your lordship? On the last occasion in SLST 2016, it was a school-wise vacancy position was maintained. But this time, it's a centrally the vacancy position has been maintained by the board. Now, if your lordship sees,
Is there any vacancy in Persian PG?
One. No, Persian Urdu. In
Persian
Persian Urdu, there is only one vacancy.
Oh.
Therefore, if it is a centralized vacancy position is there, the 100-point roster is to be followed there. Now, kindly see the first point in the 100-point roster.
Yes.
The first point in the 100-point roster is a scheduled caste.
Hmm.
Therefore, since there is only one vacancy, and it is first time from the school vacancy position, first time it is being done centrally, the first roster point is to be maintained. If there was two more, then there will be one unreserved and one EWS EC also. But since there is only one vacancy, the first roster point is being
No,
followed.
doesn't matter. Then a scheduled category candidate will go in the Persian PG.
Scheduled category, the first roster point is scheduled caste. We'll have to maintain the
Yes.
roster point.
Maintain the roster point. This issue is with the subject. Persian is the subject.
Yes. But there is no, if at all, no scheduled caste candidate is available, Malad. This itself, Malad, addresses that issue. That what is to be done in case, Malad, the appropriate vacancy is not there. Appropriate candidate is not found. But Malad, there cannot be any impediment that because there's a SC reserved, Malad,
This is not an SC candidate.
no, Malad, this post, it is a Persian Urdu medium. It is a Persian Urdu medium.
This is with regard to the subject. Is there any vacancy in the Persian subject?
Persian subject in Urdu medium, one vacancy is there.
There is.
Yes.
Have you advertised it?
Yes. It has been advertised, Malad. And Malad, it is, they have annexed it also. They have annexed it also. It is not quite legible. So Lordship may take this, Malad.
My lord,
They are not agreed by that. They say that why it will be SC reserved.
Not a word has been mentioned as to why it will not be SC reserved.
I have come, Malad, reading the brief. The brief case is that why it will be SC, why it will not be unreserved.
He did not make any submission.
When he is making submission at the bar, I'm sorry to say this, Malad.
My submission before your lordship
Is that there is no Persian subject
Persian, no
vacancy?
Persian,
Yes.
that is scheduled caste. I am the jail caste.
So that caste
is not his right. He cannot take
caste
out.
doesn't have any grievance.
No, he is saying, Malad, his grievance in the writ petition is that there is only one vacancy and it is SC reserved. Therefore, you make another vacancy which is unreserved.
That cannot be.
So that I can participate, but
No,
that is not his
no.
fundamental right.
That is. What is your case in the petition?
My submission before your lordship that the Persian subject vacancy not in the vacancy list.
Yes.
That is not only.
Have
that,
you made out this
not
case in the
only
writ petition?
Yes, madam. That is not only that.
Where have you mentioned?
SSC or state government cannot change the 100% roster. This time because it is a de novo process, de novo recruitment process.
You
Supreme Court.
show the according to the state there is one vacancy in Persian.
Yes, 52.
He has annexed it. He has annexed it. I have
Then
given.
what is your case?
But my case is that the Persian general vacancy. That is.
This is for the first time you uttered this word.
Paragraph 18 is his case. Kindly see paragraph 18.
Please come.
52. That's it. Kindly. They cannot.
Petitioner is a teacher of Persian.
They cannot change the roster, my lord.
The subject.
This is the ongoing process, my lord. With due respect and committee, lordship kindly look into the order of the Honorable Supreme Court.
His allegation is that the commission did not disclose the vacancy in the subject Persian in the advertisement floated for recruitment of assistant teachers in the year 2025. Stop paragraph. From the documents annexed to the writ petition, it appears that the commission has, not commission, the West Bengal Board of Secondary Education has already declared that there is one vacancy in subject Persian and the same is reserved for the scheduled category candidate. Scheduled caste category candidate. Stop. The petitioner is a member of the general category. Stop. Submission is that one extra seat ought to be kept aside for the general category candidates. Stop paragraph. According to the state, comma, the 100-point roster has been followed and the first vacancy in the 100-point roster is reserved for the scheduled caste category. Stop. There is no further vacancy in subject Persian. Stop paragraph. The grievance of the petitioner for
and they reduce the vacancy pursuant to the Honorable order of the Honorable Supreme Court, they cannot reduce the
That
vacancy.
point has been dealt with in Arunima Pal, my lord, I can show.
All judgment has already gone pursuant to the order of the last order of the Honorable Supreme Court.
And the prayer of the petitioner for declaring fresh vacancy in Persian subject in the general category cannot be allowed by the court. The writ petition fails and is hereby dismissed.
My lord, next matter is also same, but the subject is home science.
They allowed to sit in the examination and thereafter say.
Challenge the recruitment process. You cannot say you give me one more vacancy. That cannot be. You have to take a proper approach. Same thing.
Same thing, but the subject is home science postgraduate. Home science.
Home
PG.
science also you do not have a
Home science also one vacancy.
Only one
And therefore the
vacancy.
first roster point of SC has been applied.
Home science করে দেবেন। আচ্ছা ঠিক আছে next seven yes
Here, Lordship may kindly takes up, I'm challenging the list of 3,512 allegedly to be আমার বুঝতে হবে।
Niket. Yellow.
Allegedly,
petitioners are there.
400 something petitioners. Our names have been included.
495.
Our names have been included
86.
in the list.
85.
Our contention before a lordship is that
How many court fees have you paid?
my lord,
Court fees.
I will give the deficit forces. If it is not paid, I'll replace.
Your names are there in the list of
Yes,
candidates.
3,512 candidates. Now, firstly, kindly takes up volume 1. Show who are volume 1 of the papers. Yes.
Yes.
Page 100 onwards. These are our OMR sheets. Lordship would see these are all filled up OMR sheets. These are not blank OMR sheets. Now, my lord, that is our standing before a lordship that we are not within that category. Now, kindly takes up the, my lord, judgment passed by the Honorable Supreme Court. No. But I have not annexed it. I think lordship is having one copy, or lordship kindly keeps this copy. This is my lord Boishaki Bhattacharya, my lord. Kindly, it's easier to handle, my lord. Kindly comes first to internal page 9. Three hundred 363 is the, my lord, paragraph which was quoted. First, second, third paragraph has been placed extensively before your lordship. Kindly takes fourth. Persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointment must return all remunerations and benefits received by them to the state exchequer along with the interest calculated at 12% per annum from the date of receipt thereof till disposal within a period. So these are the categories who have been directed to be refund their salaries. My contention is that these are the tainted categories because that has been interpreted subsequently by a division bench of our honorable court. Because in this order, in this judgment passed by the Honorable Supreme Court, lordship has, the Honorable Court has in paragraph 45 upheld the decisions. Kindly comes to paragraph 45 straight away to the concluding part, or my lord, may I just first place paragraph 29 and thereafter so that it is chronology is maintained. Paragraph page
paragraph 25, page 29 has been placed yesterday. This is the submission of the commission which has been recorded and set out. In the written submission, paragraph 25, that is page 29, internal page. This is in the written submission filed on behalf of the SSC in this court. Two tables have been furnished. Table 1 pertains to candidates who either jumped rank or were appointed despite not being in the panel. Their details as under. We are not these persons. Rank jumped, out of panel but still appointed. There is a common category there. Persons who were out of panel but were still appointed had rank jumped. So therefore the figure comes to 381 in group C. I am concerned about group C and group D. And the other figure is 608. It comes to 989. Lordship has directed publication yesterday of these persons. Now next table. Number of candidates with alleged OMR score mismatch as per CBI image. Group C, we fall in this. 3481. Group D, 2823. Now there is a next panel, next malord column. Number of candidates out of B who were appointed. So therefore all these persons in respect of whom OMR mismatch was found was not appointed. Kindly see the figure is less. It is 782, 1911, 2693 is the total figure. Your Lordship yesterday has directed publication of 7293. 7293 is the figure if the column A is added up. 3481 plus 2823 is equal to 6304 plus 989. So yesterday, that is why I was making submissions. Yesterday, your Lordships has been pleased to direct the OMR sheets of persons who have not even been appointed. My contention is that would also include, this is not my clients, but I wanted to draw your Lordship attention because it's our duty to point out things before a Lordship. So therefore, 7293 would be including persons who have not been appointed. Now, my lord, my contention here is 782 plus 1911, 2693. Now, my lord, kindly comes to paragraph 45, the conclusions. That is at page 39. The last question which relates to the relief and whether it is required in modification, we find no valid ground. Page 39. We find no valid ground or reason to interfere with the direction. Here, the Honorable Supreme Court has upheld direction that the service of the tainted teachers were appointed must be terminated. They should be required to refund the salaries. So while saying so, the Honorable Supreme Court is referring to paragraph 630, 360. No, 630. 360, yes, sorry. Now, my lord, kindly takes up the judgment. And here, my lord, now kindly takes up the judgment. Now kindly takes up volume 2.
From all this submission, what is the point that you are
trying to is volume 2. Volume 2, 2 paragraphs. Paragraph 31, 32 of the judgment passed by the Honorable Division Bench, which starts at the first page of volume 2, 145. This is the judgment dated 10th July 2025. Reads out everything. Here, my lord, the rules for challenge and all these things. Kindly comes to 167, running page, paragraph 31.
Yes.
In deciding the tall claim made on behalf of the tainted candidates, we may refer paragraph 363 such and such of the judgment. It is being quoted. 4 is persons who had appointed outside panel. It is being quoted. I will not repeat. Paragraph 32. Para 3634 has classified 3 categories of candidates who can be described as tainted candidates. So these are the 3 categories which can be described as tainted candidates. Our division bench says this is binding as of today. No challenge has been thrown to this. There is no interference. Number 1, persons who have been tainted outside the panel. We are not outside the panel. Number 2, persons tainted after expiry of the panel. We are not after expiry of the panel because expiry panel is paragraph 31. Persons who have submitted blank OMR sheets to obtain appointment. We have not, my lord.
You fall within which category?
Nothing. None of this.
What is the illegality for which you are?
My name should not have been included. That is my contention. Since I am not falling within this 1, 2, 3 paragraph, my name has been erroneously included.
And
my name is, we do not fall within this thicker. This is the Miller short point that I wanted to agitate it before Lordship. And yesterday when your Lordship was directing, I just wanted to, my lord, point it out to your Lordships that this figure, which was being, my lord, conversed before your Lordship, would also include persons who have not been appointed. These are the 2 short points, my lord. That is why I wanted, my lord, your Lordship may kindly hears me, and thereafter, my lord, in this list, the names of another list is there.
The list.
My
Where
lord?
is the list?
Impugned list. Impugned list is annexed. Page 185 onwards. Entire list is there. Ending at 3512. Now, কি করে 3512 টা arrive করেছে দেখো। They have included the entire category. That's my very short point, Pala, that I want.
Entire category means?
Entire, my lord, this figure, my lord. OMR mismatch category. OMR mismatch. This OMR mismatch category.
Yes. So OMR mismatch will certainly come.
My contention is that the division bench has held that there will be 3 categories of tainted candidates. In that 3 categories, OMR mismatch has not been interpreted. The division bench has interpreted paragraph 363.
Sir, the Supreme Court has affirmed the order of the division bench.
Yes. And thereafter, the division
Thereafter,
bench.
the court is not concerned because day before yesterday or a few days back, Supreme Court has
I have
mentioned
seen that.
to follow only Boishakhi passed by the Honorable Supreme Court and nothing else.
After that, nowhere, not in the Supreme Court, not in the division bench, there is nothing which shows who are the tainted categories.
The court will
It is
not
only left to interpretation of the court.
The court has specifically made it clear, the last day's order,
Like order
that the order of Boishakhi passed by the Supreme Court should be the only consideration, nothing else.
Yes.
Why will the court look into all
Because
these things?
in Boishakhi, it has not been specified who are the
It
tainted.
has been.
Paragraph 45 is the tainted. Then paragraph 45 upholds 363.
Yes.
That is, and
So that
363 is being interpreted.
How can that interpretation be looked into because the Supreme Court is there?
Then kindly see 363. 363 doesn't include
Show
OMR
me
mismatch.
that last
Yes,
week's
yes,
order.
So if your Lordship reads 363,
363
itself, it doesn't include OMR mismatch.
Sir, the Supreme Court on date is 26th of November, right? Clearly mentions that the High Court shall examine the matters influenced by any of the observations or merit made by this court in the orders passed after the decision in
Passed by this court. Passed by this court means Supreme Court was meaning to the order dated 17th March 2025. March naki April, 17th April. By which, my lord, this honorable court directed that the teachers would only continue.
The High
And the
Court shall
non-teachers will not continue.
also be mindful of the fact that the untainted candidates
Yes,
were
yes.
allowed to sit, such and such,
No one should slip in.
and no one should slip
No
in.
one should slip in. I am saying so.
See,
There has to be a specification. No one should slip in.
the High Court shall
Paragraph
ensure
363 itself.
tainted candidates are permitted. Please come.
Yes. 9 and see
The
paragraph
petitioners-
363. Kindly, my lord.
The-
Paragraph 360 doesn't include women mismatch. This paragraph 363.
Do one thing. You file the deficit court fees first. Please come. The instant writ petition has been filed by 475 candidates by
95.
depositing only one court fees. Stop.
490,
Leave is granted 495.
495, page 85.
495 candidates. The leave is granted to the advocate on record of the petitioner to submit the deficit court fees in course of the day, tomorrow, by course of tomorrow. Stop.
Tomorrow is also very difficult. 200
of the week.
230 into 400 except account.
200, not 230. It's 200. 200
Plus-
to 495,
Yes.
494.
Quite big.
So what? So
I have to
candidates-
manage. This has to be. I will do it.
Many candidates have come forward.
Yes.
By না tomorrow পাচ্ছে না দুদিন দিয়ে দিন আরো আজকে 2 তারিখ 3 তারিখ 4 তারিখ 4th
Yes.
4th ঠিক আছে release the matter on 8th December.
Well, tomorrow is the last date, my lord. Tomorrow, 5th.
5th is the last date. 5th I'll fix it. 4th by 4th you pay. We'll list it on 5th. The petitioners' names appear in the list of tainted candidates published by the West Bengal Central School Service Commission. Stop. They challenge the list and submit that their names have been wrongly included in the said list.
Oh, it has been extended
Till
8th.
8th. You want the matter to be posted on the 8th or the 5th?
6th.
6th Saturday.
Oh, then my lord in the 8th. 5 তারিখই থাক দেখা যাবে
5th এই থাকুক
হ্যাঁ থাক
ঠিক আছে in this said list. Stop. What is the commission stand?
Well, then I would like to just place this order of this court, this honorable court, passed on 2nd September 2025. Would my lord kindly have a...
You say how the names came in. It is from the CBI's list. It has come.
Everything from CBS.
my-
I'll also
my-
place
Marks they
CBS.
obtained was not matching with the marks scanned by CBI.
Yes, according to the commission,
Only one
list has been
paragraph of the
published
CBI
relying upon the data forwarded by the CBI. ঠিক আছে? Whether the list was properly prepared or not will be decided on the next occasion. Relist 5th. Come back. Yes.
Well, I'll be relying upon the affidavit of CBI also.
14.
Which is Delhi.
Wait.
8. Yes. Who is your other side? 2023 matter? Yes, what is it?
The family pensions in respect of the unmarried daughter. Ultimately, the application was forwarded to the DI. DI has been granted, all of the order has been complied with, but due to the pendency of this writ petition, she is not given. Now, in the case of Sobita's Rai's judgment is applicable to this case, whereas the
Is it a pre-81 case?
Pre-81 unmarried daughter. 1968 married the father died. Thereafter pension payment order issued in favor of the mother. Mother died. and thereafter made an applications for granting family pension.
Yes, what is the stand of this
Malad,
case?
Director of Pension, Malad, return back the file in 2024. Malad, observing that, Malad, your lordship knows 539 is the guiding factor for Malad pre-81 pension scheme. There is no
Shobita Roy is there.
Yes,
Please
yes.
make
Malad,
submission
I
on
am
that.
submitting, Malad. They did not consider, Malad, paragraph 19 of the Shobita Roy.
Please come.
Only thing, Malad, DI instruction is that, Malad, school is required to submit document. This is the, Malad.
Did the DI seek for documents from the
Yes,
school?
yes, twice, not one.
All right,
Twice.
not forwarded.
Not forwarded.
Please give.
Twice.
The petitioner is the unmarried daughter of a deceased school teacher who was covered by the DCRB, who died prior to the promulgation of the DCRB scheme, 1981. Stop. The petitioner relies on the judgment delivered by the special bench of this court on 20th June 2023 in the matter of Shobita Roy, State of West Bengal and others versus Shobita Roy in MAT 608 of 2021, IA Can 2 of 2021, page 24. Stop. The court specifically held that the benefit of family pension can be extended to unmarried daughter of an employee who died prior to coming into force of the DCRB scheme, 1981. When did the employee die?
1968.
1968 he died?
Yes.
আচ্ছা ঠিক আছে learned advocate representing the the state respondents relies upon the communication forwarded by the not communication instruction forwarded by the district inspector of schools secondary education Bankura, where from it appears that the headmaster of the school was asked for submission of all necessary documents for family pension in favor of the petitioner. Midday office memo number 43/S dated 6th January 2023. Stop. Despite reminder granted to the school, Mama, the documents as sought for were not forwarded. Stop. According to the DI, as soon as the papers are submitted by the school authority, pension paper of the petitioner will be forwarded to the Joint Director of Accounts, Bankura, for vetting. Stop paragraph. Photocopy of the communications made by the District Inspector of Schools to the headmaster of the concerned school has been annexed with the instruction forwarded by the DI. Stop. As the right of the petitioner to receive pension has already been settled by the court, accordingly, the authority ought to take prompt necessary steps for finalizing and thereafter disbursing family pension in favor of the petitioner. Stop. As it appears that the school is not responding to the various communications made by the DI. Accordingly, the DI is directed to make necessary arrangement for collection of the required papers from the school authority. Stop. If the papers of the father of the petitioner who expired way back
I think my mother was getting
on 19 September 1968 কি বললাম right is not readily available, comma, then the papers relating to the family pension received by the mother of the petitioner, Bokul Rokhit, who expired on 20th May 2020, may be looked into for the purpose of preparation of the family pension file of the petitioner. Stop. In any event, the documents meant for finalizing the family pension of the petitioner shall be made ready positively within a period of 8 weeks from the date of communication of this order. Stop. The authority, the DI shall ensure that all papers are forwarded to the DPPG for issuance of the PPO in favor of the petitioner. Stop. All the authorities shall ensure that family pension is released in favor of the petitioner positively by 31st of March 2026. The writ petition stands disposed of.
for the petition in this matter is regarding whether there will be rotation in cooking midday meal or there will be one single self-help group will cook. Now, there is a coordinated bench judgments, including your lordship's judgment, where lordship has held that no, there is no rotation system is permissible because the rotation system has been withdrawn. May I just draw attention of few pages to your lordship? Kindly come to page 27 for once.
What is the stand of the state?
My lord, I'm, my lord, submitting, my lord, one government memo, my lord, which enumerates 1412 to 2018.
Have a copy.
Which enumerates, my lord, that the duty has been casted, my lord, upon the managing committee of the school. My lord, kindly turn to page 8 of the memo. Duties and responsibilities of the VEC and MC, means managing committee and school level committee. If your lordship got it, my lord, the VEC and MC monitor the MDM program in the school in their jurisdiction. This committee ensures that the participation of the parents and the community in this program, they will engage the self-help group following the norms prescribed. They will also ensure that one of the members countersigns the monthly statement bill to be submitted to the BDO for payment. So the state government role is only to monitor, for not to engage the self-help group.
How are you monitoring if there is a rivalry between two self-help groups? What will the school do?
It is absolutely, I am submitting on instruction, my lord. It is the absolutely prerogative of the management of the school, managing committee of the school, my lord, to decide over it. So, my lord, the government has no role to play.
What are you supervising?
My lord, supervising whether the meal is actual or not, my lord. It is also, my lord, enumerates the power and duties of the, my lord, BDOs, district magistrates, and everybody, my lord, involved in the scheme, my lord.
Duties. And if there is a fight,
my lord,
then none of the children will get food.
My lord, the school authority has the self prerogative, my lord. Managing committee of the school has self discretion, my lord, to decide the issue. Government cannot, my lord, take
May I
any
respond to it?
participation, my lord, into it, or
Possibly.
they don't have any role to play in it, my lord. So for the all these students are getting, my lord, benefit of the same, my lord, it is only look out of them. But if the two persons are quarreling between them, my lord, so my lord, government has no role to play.
Government has
No, my lord.
May I just show to your
As
lordship?
per the my lord said
No,
notification.
this is a scheme. I have gone through this scheme. There is another scheme also I have gone
Please
through.
show.
Yes, my lord, this scheme, there is nothing which speaks of this. This is just a general guideline which says.
Please show what is the scheme that
No,
you
no, I'm showing the documents, my lord. My lord, kindly come to page 32 for once. First, my lord, page 27. As my learned friend has rightly stated that it is for the school to engage.
Yes.
Kindly see page 27. That the school certifies that I was engaged since 2008 and I cooked meal up to September 2023, but subsequently other groups came and put padlock and cooking was disrupted. Now, my lord, kindly come to the next page. It is the order of 2nd of June 2009, where the DM writes, in continuation of our memo number such noted above, this is to inform you that the cooking of midday meal has not yet started in many schools under your block. In order to run the midday meal immediately, we have no other option but to start the midday meal immediately with the existing SHGs, that is self-help groups, who are already engaged for the purpose. You are now requested to start the midday meal within 3 days with the help of existing self-help groups and submit a report to the undersigned. So we were existing since 2008. This is 2009. Since we were existing, we are continued. Now, my lord, kindly come to page number 31, where the BDO Suomoto introduced one rotation system. Kindly see, my lord, it says এত দ্বারা জানানো হইতেছে যে there is no official notification. That was just a paper that says that you have to monitoring committee পুরনো দলের সহিত নতুন দলগুলিকে রন্ধনের অনুমতি প্রদান করা হইবে, which created the problem. Previously it was not there, which created the problem. Now, my lord, this letter was withdrawn. Kindly take page 32, the next page. The BDO himself withdraws this letter on 26th of November 2015, has notified that the previous order issued with this office memo number such and such regarding an arrangement of cooled midday meal in education institution is hereby withdrawn, and any action taken with reference to the above said order is declared null and void. Midday program in education institution should have been in operation as usual as per existing government guideline. All concerns are accordingly. Now, my lord, kindly
Is the school a party?
Yes, my lord, these two notifications has been considered by my lord Justice Chakraborty and passed the order. My lord, kindly see
It has
the
been
order I
withdrawn,
have.
my lord, since he has no authority. My
No,
lord.
no. That is why it has been considered. My lord, this kindly take the stand of the state in Justice Chakraborty's order. It has been recorded.
Serve the school once.
Very well.
Please
Sir, may I just place once? It has been considered already.
The matter relates to
Your lordship's order is there.
engagement of self-help group for running the midday meal scheme in a school. Stop. The representation of the school will be required for the purpose of effective adjudication of the instant list. Stop. Let notice be served upon the respondent number 5. Indicating that the matter will appear in the list on 7th January 2026. Stop. Let a copy of the notice be also served upon the officer in charge, Jhalda Police Station, for onward transmission to the school, communicating the order of the court.
Yes.
Stop. In the event the school is not represented, then ex parte order will be passed.
There is only one difficulty. I don't know.
Take this back.
Whether the present school is in aligning with the present cooks self-help groups. That I do not know. I'm only.
You give notice.
I will. I'm only restricted to the notifications and your lordship's order, which has already been passed.
Deeply obliged.
Grateful to your lordship. Obliged to your lordship.
Item 10, your lordship, I'm appearing for secondary board. My lord, I'm praying for an accommodation of this day because my lord, I have the brief I have left back, your lordship. Your lordship directed to file a report, my lord. The report is ready, but somehow the brief has not come to. My lord, petitioner was here. No, my lord, petitioner was here.
In this matter, Mr. Sudipto Manda appearing
he
for the
was here.
petitioner.
Where is he?
He is in code number 42, my lord.
My lord, he was here.
Going to make submission.
My lord, I am paying for Passover, my lord.
Passover.
My lord, kindly make it not today.
Not today.
Lordship.
I appear for the petitioner, my lord. When on last occasion, your lordship passes an order, my lord, directing the respondent to file a report, my lord. The matter relates to my lord house rent allowances, and they rejected my prayer, my lord. Kindly see page 27. They have rejected my prayer on the basis of a memo. The impugned order is at page 27.
Yes.
They have rejected my prayer on the basis of a memo, my lord. I have annexed. My lord, next page, page 28.
GO 955.
My lord. My lord, the GO is absolutely, my lord, saying in favor of petitioner, my lord. There is no any words, my lord, against me. And that is why, my lord, your lordship directed them to file report, my lord.
Yes, please, report.
Yes.
My lord,
My lord, I have taken instruction from commissioner as well as DI, because in the earlier order, my lord had directed, because the department is the appropriate authority, commissioner to be, my lord, consulted for making the clarification. But in the order, my lord, DI itself is itself there, my lord, but commissioner has been directed. My lord, I have taken instruction from commissioner as well as DI.
Give a copy to her.
Yes,
so
I
that
have
she
given.
gets to know.
My lord,
Din.
my lord, again, my lord, they have rejected my prayer on the same, on the basis of same memo, my lord.
But has any
And-
ground been disclosed?
Just
Yes.
same thing, my lord.
What is the
Nothing.
ground?
5, clause 5.
Clause 5, page 29.
Clause 5.
Yes, my lord.
The director of school education with his view forward the same to the school education department.
No, my lord, clause 5.
Of my petition, writ
Petition, that is page 29.
Page 20.
Page 29 of the Malot GO has been annexed is page 28, and relevant page is page 29, clause 5.
Read out.
Malot, then the Director of School Education West Bengal with his views forward to the same to the School Education Department Government of West Bengal for consideration of issuance of order in respect of full HRA. Drawal of such full HRA shall be effected from the first day for the next month after issue of this memorandum in this respect of the incumbent.
What does this mean?
My lord, this memorandum is there. What the memorandum purports, that memorandum is an order favoring HRA in favor of the petitioner. Memorandum that they are trying to interpret, and as they have decided in the year 2024, and by that time, my lord, the entitlement 2070-2090, the entitlement is there, but they have actually decided 2024. And if by this, my lord, clause 5 will be, my lord, taken note of, then it will be, my lord, from the next date, as they are decided in the 2024, then that will be in the next month. That's why they have taken the point that area HRA is not, my lord, acceptable by this within this purview of this memorandum. But I
have
think that this is sustainable, because claim has been contemporaneously raised by the petitioner. If they are deciding in 2024, my lord, what can be?
It is their fault.
Yeah. I'm very clear.
Yes, please come. The petitioner's claim for grant of full house rent allowance has been rejected by the authority. Stop. Authority relying upon memo number 955, page 28. এটা লিখে নেবেন তো ও এটা লেখাই আছে এটা লেখাই আছে Stop. It appears that the petitioner raised her claim for house rent allowance on regular basis as and when the same fell due, but the authority, for reasons best known, kept the claim of the petitioner pending. Step. The spouse of the petitioner is not employed with the state government. Stop. The the judgment passed by this honorable court in the matter of, give me that Moushami Bishwash petition. अच्छा, आपने लिखे नहीं? Court on such and such date in such and such, in the matter of such and such, categorically held that the teachers of the non-government schools slash sponsored schools slash aided schools will receive HRA if their spouse works with some other organization but not the state government. Stop. Next. In view of the above, the rejection of the petitioner's prayer for grant of full HRA cannot be held to be a valid one. Stop. The same stands dismissed. Stop. The district inspector of schools, which place?
That is Barakpur.
Secondary Education, Barakpur, North 24 Parganas, is directed to process the request of the petitioner for claim of the petitioner for grant of full house rent allowance and ensure that the same is paid to the petitioner positively by 31st March 2026. Stop. As the petitioner would be paid her legitimate due at a delayed point of time, accordingly, she will be paid interest on account of such delayed payment at the rate of 5% per annum on the due amount calculated on and from the due date till the date of actual payment. The impugned order of rejection dated
25th January
2024 is set aside. The writ petition stands disposed of. Instructions, due to instruction be written with the records.
Moushami, WK 1389, Moushami, later.
I'm grateful.
Before my line of defense starts, my lord, there is an impediment on my part. My lord, today morning I have been interested with this matter. My lord, I have not looked into the brief, my lord.
DI was supposed to file a report
Lord, I have
as to whether the petitioner's application dated such and such will fall within the 10% of the teacher's strength.
only seeking for 2 days accommodation, my lord. Only
Four times, my lord, the order was passed to file a
my lord,
report.
the Ashwell advocates perhaps not in the panel.
My lord, what I am praying for. My lord, I have last occasion I have handed over a, my lord, the staff pattern. Headmaster also signed in 2025. Your lordship it will find, my lord, the petitioner is a geography teacher. There are other 4 geography teachers, so single teachers is not a bar. Now the petitioner's application was rejected 10%. That is 2021. 2025, my lord, there are 45 teachers. None of the teachers applied for transfer. My lord, your lordship allow me to submit a fresh application. If anybody have not applied, my lord, for transfer in 2025 or within 10% of the teachers, your lordship direct the school authority to forward my application.
The petitioner seeks transfer. Stop. Her earlier application seeking transfer stood rejected in the year 2021 on the ground that her application did not fall within the 10% of the teacher's strength eligible for transfer. Paragraph. It appears that it appears now. According to the petitioner, there is scope for consideration of the petitioner's application seeking transfer as according to the petitioner, none of the teachers have applied for transfer recently. Stop. Prayer has been made to permit the petitioner to file fresh application seeking transfer so that the same may be considered by the school authority. Stop paragraph. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to seek transfer by making application in a prescribed format. In the event such an application is made, the same shall be considered by the school authority in accordance with the prevailing guidelines and rules. If the prayer of the petitioner for transfer is allowed by the head of the institution, then steps shall be taken to forward the same to the concerned district inspector of schools for taking necessary consequential steps.
You also kindly observe that if it is not within the 10%,
the
or single teachers, then forward.
School shall take steps in the matter within a period of 8 weeks from the date of receipt of the application from the petitioner, and if allowed, forward the same to the district inspector of schools within a further period of 8 weeks thereafter.
No, you also kindly observe that if it is not.
Yes.
My application, my lord.
I'm for the commission.
Kindly come to the page 15, my lord, straight away. My lord, actually, I was recommended as an assistant teacher. My lord, thereafter, next page, page 16. My lord, school authority has given me the appointment letter and to instruct me within 30 days we will join. My lord, thereafter, one reminder, 15th January 2025, that was also issued by the
What
school
is the
authority.
issue pending before the division bench? Submission was?
Yes.
Rajiv Brahman.
Shukumar Singh. Shukumar Singh.
Yes.
Yes.
My lord, kindly come to the page 4 of the that judgment, my lord.
Dismiss করে বা অনেকগুলো clarification দিয়ে চলবে। Extension of recommendation.
এটা কি হচ্ছে? Attendant.
Do you fall in the same category?
No, my lord. Actual, this is for appearance of the counseling.
Yes.
Actual, I was recommended.
Recommend.
Appointment letter was issued.
So it's
only
different.
My lord, actual, this is not the same matter, my lord. Actual, considering the situation and present situation of the school, my lord, actual school service commission may be considered. If your lordship kindly direct, I have communicated the representation. If consider actual 3 months.
Listen, your recommendation expired 1 year back.
My lord, kindly see the page number 6.
1 minute. What is the stand of the commission?
My lord, firstly, what needs to be checked is whether the candidate was a tainted candidate or not.
You have not checked.
No, I have not, but the prayer is literally an admission of the fact. Kindly see the prayer at page 8. It is continuing on page 9.
Yes.
He says that
Innocent victim of systemic corruption.
yes.
Is your name there in the tainted list?
No.
Sure.
Yes, my
And kindly see paragraph B also.
My lord, actual, I was joined in the lab assistant earlier proceedings. My lord, that was gone.
Yes, that is what I
was gone, my lord, by the virtue of the Honorable Supreme.
At 2016 recruitment process.
My lord, yes. Thereafter, my lord, I have already been appeared in that time. SLA 16 has come, and I have appeared on that proceedings. On that SLST 16.
In the 16 recruitment process,
Yes, my lord.
does your name
Yes.
feature in the list of tainted candidates?
No, ma'am. No.
Check up.
My lord. Yes.
If his name is there, from
Then,
here and
yes.
out.
Yes.
And if his name is not there, does the vacancy still remain?
No, that I will have to check because
have to
possibly
check.
there will not be any vacancy also, and that apart I will be opposing. So even if there is a vacancy, I will be opposing. He will
Yes.
not. He cannot be entertained at this stage. Our panel has expired in the meantime, and he
Expired means expired long back.
no.
What in the meantime?
Huh?
After primary 25 September.
25th September 2025 it expired. He was called in the first phase of counseling. He apparently has not joined.
First phase of counseling when?
Yes, that was
15 2024. 19/11/2024. Page 15, my lord.
yes.
See, the Supreme Court passed order in March 2025.
Yes. That is why after losing their jobs, now they're all trying to come into the upper primary selection process, which at that point of time they thought was not necessary. They did not visualize that maybe the entire selection process will be set aside. Though the division bench had already set the entire selection process aside, but they were hoping Supreme Court will give them something.
19th
But that order did not.
I'm just trying to understand. That means this candidate never joined in terms of the 2016 recruitment process. He did join.
No, he joined and lost his job.
That is in 2024-25 when
yes,
the order
that
is
was
passed.
the 2016 selection process.
Yes.
It ultimately, the entire process got set aside by the
Right, then
judgment on 3rd April 2025.
Where does he want to be repatriated?
Now he wants to, he had also applied for upper primary.
All right.
He was there as a group D, lab attendant group D. Now that
So
he
he
has
wants
lost
to
his
go
job
back there.
there and he did not
Pursue
think
with
it,
his claim this
yes.
year.
In a similar matter, my lord has already dismissed one matter with regard to teachers. He is a group D. Let us come back on the next date with the instruction and I'll also bring that order.
Please come.
Might not be a representative.
The order dated 25th of November 2025 passed by the Honorable Division Bench in MAT 1477 of 25 with IA Can 1 of 2025. West Bengal Central School Service Commission and another versus Shukumar Singho and others has been placed before this court. Stuff. Learned counsel representing the Commission seeks time to revert with instruction as to whether the petitioner falls in the list of the tainted candidates published by the Commission. Stop. Instruction shall also be obtained as to whether there is any vacancy where the petitioner as to whether the vacancy in the school where the petitioner was recommended still exists or not. Stop. Information shall also be taken as to whether there are any other vacancies for accommodating the petitioner. In the event his prayer in the writ petition is allowed. Stop. Relist. When 15th.
My lord will kindly record our submission that this Sukumar Singh does not apply in the case of the petitioner, and that in any event we are opposing his prayer for. Because my lord has given quite a positive order which
No, in
might
the
be
event,
read.
in the event his prayer is allowed. You never know. His prayer may be allowed, may not be allowed.
No, but the instructions, vacancies, other schools.
Let's see. Because in respect of absentee candidate, the division bench is allowed.
Yes.
They were absent.
Under certain conditions which my
Right.
learned friend will not
May
be
not,
able to fulfill.
may not.
I will.
At the first blush, it seems that it is not covering his case. Still, we'll see. I'm grateful, Your Honor.
No time for the petition.
I'm appearing for the commission, my lord.
My lord, the issue, my lord, last occasion, seek short for the time, whether petitioner's case is age relaxation should be allowed or not. My lord, petitioner age relaxation should allowed or not. Commission short for a time. Instruction, my lord, senior advocate, Mr. Kalyan Bandyopadhyay appearing. My lord,
why age relaxation?
My lord, age relaxation, petitioner has crossed, my lord, 40 years of age, which is, my lord, kindly turn page number just rule, my lord, once, page 25. Sure. Page 25 once, my lord, of my writ application, my lord, age relaxation, your lordship may, my lord, in respect of 9-10, my lord, age limit minimum 20 years, maximum 40 years. 11-12, my lord, similar. My lord,
Are you a fresh candidate?
No, my lord. I am job loser. In
You are a job loser.
I am, my lord. I have applied in respect of 9-10 and age relaxations given by the authority. But when I try to enter 11-12 level, my lord, the system is not permitted me. My lord, there is a window for necessary correction. Window is activated, my lord, up to my lord. Window is activated up to, my lord, 11th of August 2025. Subsequently, Honorable Supreme Court said no. Said there is age relaxation should given to the all the ballot in all the both the selection process, which was come in 29th of August 2025. My lord, this is my case, my lord. And my lord, in this juncture, my lord, as last occasion, commission sought for a time. If there is any, they seek a time that whether that it can
Yes,
be accepted or not.
We have filed a report, my lord.
You have?
Yes, we have. Yes.
Yes, my lord, report they have filed.
What does it say?
Lord, he has been negligent to fill up the form in the next part. One part he filled up correctly. Now he wants to edit his date of birth in the next 11-12 selection process, which he has not filled up. My lord will kindly see his prayer.
Yes, paragraph 4 and 5, my lord, they have stated, my lord, in their report.
The prayer is for correction of date of birth. There was an ample opportunity given, my lord. He did not correct it.
No, my lord, I have a little submission, my lord. Opportunity given up to August 14. My lord, subsequently they cleared their stand in before the Honorable Supreme Court.
It has nothing to do with that, my lord, because every other person who got the opportunity to corrected it. Perhaps only he did not.
Age relaxation is given by the court's order, Honorable Supreme Court's order, that I have annexed, my lord. And my lord,
What about
this
age
point, my lord,
relaxation issue, my lord?
this
The
point,
issue
my
is
lord,
he has filled up the form negligently. Now he
yes,
wants
my
to
lord, this
correct
point,
it.
very good. My
He
lord,
wants
this
to
point,
correct
I am relying a decision of
Where
Honorable
is
Supreme.
your date of birth mentioned?
Yes, date of birth, my lord, I have stated in my REIT application,
It,
categorically.
it
My
was,
lord,
it was
March
yes, my lord, I am
1984.
categorically stated, my lord, kindly see page number 5, paragraph number 8. There's a page number 5. Lord, last 4-5 line. Even online system is not permitted to making any application for selection process in 11-12 level. Accordingly, the petitioner input his date of birth as 5th of March 1985 instead of 5th of March 1984 in 11-12. My lord, I cannot enter in that, my lord, form. That is why, my lord, I gave an erroneous. It is an admitted fact. I am not disputing.
And this you did it in May or June when the advertisement
Yes,
came.
my lord. Yes,
Why are you
my lord.
coming
I am
forward now?
this point, my lord. This point is, my lord. Kindly see this judgment once. Honorable Supreme Court pass. If that, I will take it. My lord, kindly see, my lord. Similar issue is involved, my lord.
What is the issue?
Yes, yes, my lord. Kindly see the issue. There is a discrepancy, my lord. Kindly see the, my lord. If your lordship kindly see the paragraph number 4. Kindly see similar issue, my lord. Erroneous date of birth. Erroneous, yes, my lord. Erroneous date of birth in a selection process. Similarly, paragraph 4. If honorable if there is an, it cannot be curtailed. Their right cannot be curtailed by this way. But in 9-10 selection process, I have given a perfect input. There is no dispute. But by the time putting this question to myself, why wrong input has given the 11-12? But I was unable. My lord. That is why I put a wrong input and entered the selection. I have completed.
Because you may have 1, 2, 3, 4 cases. I over here have got hundreds of cases.
Yes.
This date of birth entry, you cannot make it properly. You are the only one that is coming up with this type of allegation. This type of allegation has not come. The caste could not be uploaded.
Yes,
It's
yes.
different. There are many things.
Yes.
But date of birth,
But when I tried to enter the actual date of birth, but system is not permitted me. I have.
how can it permit for others? System is not different for you.
My lord, if Supreme Court's order come later, and that is
So
why, my
what?
lord, Supreme Court
So you
their
are
stand
relying
is.
upon Supreme Court's order.
My lord,
You are relying upon Supreme Court's
my lord,
order.
my lord,
In one place you could upload it and the other place you could not.
my lord,
How can that be?
yes, that is, my lord. Kindly,
No.
kindly consider the situation, my lord. Kindly consider the situation.
Now the result interview list has been
Interview,
published.
no, my lord. Verification list has published. It is going on, my lord. In cutoff, my lord, my lord, my mark. I have secured low marks than cutoff marks.
Then
If 10
what
marks,
remains?
my lord, I have filed this REIT application much before.
Yes.
It
so
has,
what?
it
What
has,
are you waiting for? What do you expect from the court?
last occasion, even last occasion, first occasion, they sought for a report. They
No,
come
no.
up a report.
Yes,
Report
because
has given. They have only agitated the wrong date of birth. They are only agitating the wrong date of birth.
obviously because that is the wrong date of birth.
We have stated in my application, it's REIT application itself that I could not. Last occasion, even commission sought for a.
Which one is correct? Your 910?
1984.
910 one is correct.
910 correct.
You continue with the 910 selection process. 11, 12.
So, my lord,
If it is gone, it is gone. Continue with one.
My lord,
See
then,
if you can manage.
my lord, kindly then.
Can I one make submission? Will?
Led by Mr. Bandapal.
Well, the problem is this, that he did not disclose his experience in the 11-12 form. 9-10 he has disclosed and he has got the benefits. 11-12 kindly come to page 40. He has not disclosed. Date of birth is not the criteria, but here the problem is this page 40. He did not disclose. And Lordship knows that there are a number of cases are coming before your Lordships also.
So
Who is
you have
there?
not disclosed your
Date of birth
experience.
I could not, my lord, kindly record that.
Date of birth, they say they ignored
My lord,
date
then
of
my
birth.
lord, kindly record my submission and reliance of the judgment and my lord, pass and reason order. I have no.
Because date of birth is not the issue.
My lord, date of
Their issue is the experience.
experience. My lord, ipso facto, if date of birth is corrected, well, ipso facto I got the 10
No, no,
marks.
no, no, no.
Ipso facto I got the 10 marks. My lord, kindly visual.
Your
there is
ipso facto is with
my
you.
lord, it is my lord, admittedly.
Please come.
With the
The
leave of Mr.
petitioner
Bandyopadhyay, the
participated.
identical order. Identical order টা দেখাবো তো?
Yes, yes.
Identical order of
Let me see.
Millard.
It is under challenge, my lord.
It might be, but this is the identical order which has not been set aside as of now.
Here was any representation we made?
Yes, yes.
20th September 2020, they able to update.
Much later, but my representation is the present case much earlier representation in month of September. They have not considered the
Here
let it
also
be
September.
considered. No, say not September. At September, I mean they should consider it accordingly. My lord. Even Supreme Court held, my lord. It is I am covered by the decision of the apex court, my lord. If there is a wrong imputation, my right cannot be curtailed, my lord.
এটা থাকবে petitioner participated. এটা this will be a he and not a she. She alleges এটা ঠিক করবেন. A representation. What is the date of your representation?
Yes, yes. Representation, my lord, is
11 September 25.
48, my lord. 11 September 48.
All right, 11 September to update the details of her prior teaching experience. Achha, is vehemently opposed to submit the result of the written examination in respect of 9 and 10, 11, 12, all published. Here you filled up the teaching experience of 11, 12 or 9 and 10?
Yeah. Teaching
this
is for
case,
9,
9, 10
9,
you
10
filled up.
perfect.
So she was unable to fill up the details of prior investment form. It change হবে, huh? She was unable to fill up in respect of classes 11 and 12. She was able to fill up her details classes 9 and 10. Result written examination declared.
Interview list published,
It has
but
been
it has not been.
submitted. The result of the written exam recruitment has been declared.
And my lord, kindly record my reliance. Kindly record. Otherwise, my lord, it will create some trouble into my client.
This
yes,
I will not record specifically because date of issue is not the issue. The issue is your experience. Here, there is nothing
then, my lord,
to do with
date
your.
of kindly record the date of birth. There is no grievance against date of
They
birth.
say they have disclosed that there is no grievance.
Then
It is only
kindly
your the prior teaching experience that has
my
been
lord,
highlighted.
that submission to be recorded, my lord.
Yes. Upon hearing the parties and periodically, where is your 11 September representation? Please show me.
Yes, yes, yes. The representation is, my lord, page 48.
আচ্ছা 4 নম্বর প্যারাগ্রাফ লিখুন তো Upon hearing the submission made on behalf of the parties and on perusal of the documents annexed to the writ petition, it appears that though the petitioner mentioned a wrong date of birth in her application meant for classes 11 and 12, comma, the commission does not harp upon the incorrect date of birth. HARP, H-A-R-P. The incorrect date of birth. Stop. The issue is the non-disclosure of the past teaching, not past, prior teaching experience. Stop. It appears that the commission provided several opportunities to edit/update the prior teaching experience, to update the details of the prior teaching experience. Stop. The petitioner, comma, for reasons best known, comma, missed the opportunity to do so. 5 will remain. Yes, dismissed. You can take this judgment back. It is not required.
Not Lovely.
Next.
I beg to appear on behalf of the petition. Lord, Lordship, kindly consider the earlier order. There is a direction to submit a list.
Yes.
But
Close to the residence of the petitioner. Copy handed over to you.
Yeah.
You've got.
Lord, I cannot join there.
None of the schools where there is vacancy you cannot join.
I cannot.
Then stay at home. Don't join.
Because, my lord,
The state has already filed 3 vacancies, my lord. Your lordships, my lord, on last occasion, learned advocate.
1 minute, 1 minute. What is your submission?
My lord, my submission is that, my lord, initially, my lord, I have applied giving some list of schools. My lord, without, my lord, intimating anything that has been filled up. Subsequently, my lord, one, my lord, nearby school, there is a vacancy. There are 2 vacancies in a school. My lord, I have applied and I have indicated that, my lord, at page 41. My lord, that school, my lord, they have a earmark for second SLST. First SLST. Lord, what? Second SLST. Lord, what I am on, my lord, if, my lord, it can be interchanged. My lord, otherwise, my lord, I cannot join. Page
You
41.
see, you are seeking transfer. You cannot have a vested right to join in a
No,
particular
I
school.
cannot argue. I cannot argue.
Then, if the school vacancy is not there, what can be done?
But the vacancies are there.
No, but then that vacancy has been earmarked for a separate selection process to be filled up, isn't it? Commission,
Deny so.
what is the way out?
My lord,
Just read from there.
Yes, my lord. My lord, the stand of the commission, my lord, when, my lord, considering the transfer application, my lord, verify the service. Yes, my lord. The vacancy already reported it for direct recruitment shall not be filled up by transfer, my lord. The rules also provides for, my lord. So, my lord, if your lordships,
Please come.
my lord, kindly direct the commission
The
to
list.
give an opportunity of hearing and to give certain vacancy, my lord, since the petitioner had applied on medical ground, my lord.
The petitioner
But these vacancy, my lord, were, my lord, vacant since
seeks
2015.
transfer. Stop. A list of schools where vacancies are available nearby the residence, nearby Rage, allegedly near the residence of the petitioner, has been handed over to the learned advocate for the petitioner. Stop. according to the petitioner, her medical condition will not permit her to join in any of these schools where vacancy has been shown. Stop. It has been submitted that there is vacancy in a different school, but the said vacancy has been earmarked for being filled up in the recruitment process being conducted by the commission. Stop. Next paragraph. As it appears that the petitioner seeks transfer on medical ground, accordingly, the instant writ petition stands disposed of by directing the which commission? Secretary of the
Central School Service.
Central School Service Commission to grant an opportunity to the petitioner for opportunity of hearing to the petitioner for production of documents in support of her ailment. Stop. The commission shall ensure that a vacancy, that a suitable vacancy is identified where the petitioner may be posted on transfer. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Disposed.
Item 68. I appear for the petitioner in this case.
Well, I do not know, my lord, whether report they have prepared or not pursuant to your lordship's direction on 10th of November.
Commission.
My lord, the report is not ready, but in the meantime, in a similar matter, my lord had dismissed one writ petition, which went up in appeal, and the division bench. Oh yes, the division bench allowed, but specifically stated only those candidates who have applied when the portal was still open. So
What
this,
does the petitioner want?
he wants to.
Petitioners before your lordships are the diploma in special education educated qualified candidates. This is a qualification prescribed for the purpose of recruitment up to class 8, 5 to 8, upper primary level. Advertisement has been made by the School Service Commission that 5 to 10 we shall be recruiting only to the those candidates who are in degree in special education. We have said that we are the diploma holders, we have not the degree holders, therefore we are at least up to class 8 upper primary level, we are entitled to be recruited. That is the issue before your lordship's court, my lord, and that particular qualification has been accepted by the Rehabilitation Council that it is up to class 8, they are entitled to be appointed. We have the last date for filing the application was 24th of September. Since our applications were not, my lord, entertained, so we moved the writ petition before the Honorable High Court during the vacation, and it is the vacation based. The Honorable Judge said that you file a report to that. No
Then
report
we
has
were
been
not
filed.
engaged. It was not. I don't know whether it was served.
It was
Whatever. Then what is to be done now?
My lord, let me file the affidavit since the direction is there. I have to file it.
But then if
But
the date has expired.
yes, 24th September.
Now, how can they be accommodated, especially when you are relying upon the division bench's order, which is
No,
in
division
favor?
bench order is in my favor because only those candidates who agitated their grievance prior to closure of the portal.
All right.
We agitated
That
our grievance.
specifically-
Our representations were there prior to closure of the portal. Our representation is at last page of the
order of
No, that is not to the commission. That is not. To
14th of July 2025. The application was made to the authority.
no, not the commission. Kindly be specific. To the Rehabilitation Council of India,
Which
New
page?
Delhi.
That is at page 271.
271.
Second volume.
What
Not-
will New Delhi do over here?
They are the authority, my lord, to regulate the recruitment process for those, my lord, special education candidates. And it has been held that JL stream also they are entitled to be appointed. We have been denied, so my lord, we have made the application there.
271.
1.
271.
Last annexure.
Yes. 14th of July 2025. Application for inclusion of special education with
They're
graduation.
not saying equivalent. They want to be treated as equivalent.
Your application is for a different purpose altogether.
No, application for inclusion of D8 diploma in special education for graduate's degree as on eligible criteria for Department of School Education, Literacy Ministry, Government of India, published on 10th of June.
Right, but this is the commission must have floated a recruitment notice. This is
In
not mentioned.
September 2025.
Right,
September.
and that is not mentioned here. You could not have September 2025. The recommendation, the recruitment process is not mentioned in 271. And what will 271 do? After the recruitment notice was published, what is there to show that you applied?
No, I could not apply because I was not found eligible according to the notification.
So your application is before there, the member secretary, let the member secretary consider.
That kindly come to this particular notification that was published, that is at page 25 on 9th of September 2025. There, my lord, the last date definitely, my lord, we say at page 26, 24th of September 2025. But the qualification, my lord, lordship will kindly come to, my lord, the qualification that has been prescribed for by the West Bengal Board of Secondary Education and the School Service Commission's own notification that we are eligible for appointment. That qualification is already, my lord, mentioned. We are eligible for appointment. That has been, my lord, the notification is already there. And accordingly, my lord, we are applied.
You did not challenge the recruitment notification. That that you have not included this degree. You have kept your degree level at such a level that you cannot participate.
That is exactly prayer has been made that we should be allowed to participate even offline for the purpose of up to class 8 we are eligible.
But then, the recruitment process
has not been only notification. No, my lord, date has been fixed. No examination has been held. We are at a stage, my lord, only application stage. No date has been fixed for the holding the selection process. No date has yet been fixed.
How many court fees did you pay?
Well, I paid only single court fee. In view of the division bench judgment of Justice Jayanto Biswas, my lord,
Yes.
has considered
49 candidates coming for recruitment by paying only one court fees.
Well, if your lordship so directs, well, I shall pay the court fees.
Yes, you pay the court fee and bring the division bench's order. Let us see what happens. The writ petition has been filed.
Well, that has been admitted. Writ petition has been admitted at the motion stage. That point was not taken at the time when the matter was taken.
I never take this ground.
Date appeared on that day.
Writ petition has been filed by 49 petitioners by depositing only one court fees. Stop. The petitioners seek permission to participate in a recruitment process, which a recruitment process stop. The last date for filing the application form expired in the month of September 2025. Stop. The instant writ petition has been filed on 14th October 2025. Stop. Whether the relief sought for by the petitioners can be allowed or not has to be decided. Stop. Learned advocate for the petitioners is directed to deposit the deficit court fees in respect of 48 petitioners by 5th December.
Give slightly more time, my lord, because
This Friday, today is
Friday week.
2nd.
Friday week.
Yes. 12th December. Release the matter for further consideration on 16th of December. Learned advocate, now the parties are directed to produce the division bench's order relied upon by them. Stop.
Well, I can keep it tomorrow. Lordship, I can, the judgment of Justice Jayanto Biswas sitting with Justice Tapun Dotto, my lord.
No. The special educator matter.
Oh, that judgment is not with me, my lord.
Yes, take the note.
Copy
The report as directed to be filed by the School Service Commission. Midday order dated 16th October 2025 shall be prepared and circulated prior to the adjourned date.
Deeply obliged.
No date has been fixed as yet. My lordship can record that. Because otherwise it will be
You chose time to file the court fees. I was keeping it this week, next week, so that it can be heard. You chose So take your risk.
Oh my God.
17.
Lordship, then keep it on 6, my lord.
No, sorry, sir. Yes.
Lord, I am appealing for the School Service Commission.
Yes.
But whether or not the service rendered by the part-time teachers in government-sponsored and not the aided schools are to be reckoned for the purpose of not this experience weightage.
There was a direction for filing of a report.
They have filed a report.
Where is the copy? Is the copy here?
We have received a report.
Last question.
You filed it? No. Direction was passed on the last occasion. Where is the report?
I'm just.
All right. Yes.
We have received a copy of the report. Not may I-
This is the exception. All right. What is?
Not the only ground taken not in is unless one not for the timing. May I hand up a copy?
No, no, it's all right. You place your case.
No, that's the point. Only point. Whether the part-time service can be reckoned for the purpose of this weightage. But the sole ground taken in the opposition is that one has to work in substantive post. And I just read that particular paragraph, paragraph 7. That's the stand of the state. It is evident that for availing marks for teaching experience, a candidate should have rendered service in a substantive teaching post at the secondary level in a government aided or government sponsored school, either as a permanent teacher or on a contractual basis. So not if one works on contractual basis, it's not standing in the way. But the only objection is one has to work against a substantive teaching post. Not all teaching posts in a government or government aided or government sponsored schools are substantive in nature. A substantive teaching post is a teaching post created in any government sponsored or government aided school with the prior approval of the competent authority, which in the instant case should be the government of West Bengal. So not a post which is created with the prior approval of the government is reckoned as a substantive teaching post, and any person who has rendered service against such post, be it on a regular basis or on a contractual basis, can count this past service as weightage. Now, apropos this, please come to not these persons have been working not only against not continuously, but not they have also been not allotted regular classes and not examiners in the and not the other point is not every time the school has to renew its affiliation or not the recognition, there has to be a sanctioned strength of teachers given. But these teachers are being cited as holders of posts against the sanctioned strength for the purpose of renewal of affiliation and recognition. But it has the identity of the teachers has to be disclosed subject wise and subject wise disclosure so as to conform to the requirement of sanctioned strength.
Is it your case that the sanctioned strength teachers are not there?
And we are rendering service in such posts. Therefore, not what is a substantive post with the approval of the government. Suppose a person works for 25 years and the government does not sanction the post. Will that mean that the person is not working against a substantive vacant post? It depends on an executive decision. But not having utilized our services against the sanctioned posts of teachers in the subjects, the government is stopped from saying that these teachers who have rendered, say, part-time teaching services in the continuity are not to be counted, are not to be reckoned for the purpose of counting their past experience. Not when more so when paragraph 7 of the report of the government says that even if they are acting contractually, they can be counted. So permanency is not a deterrent measure.
Determining factor.
Permanency is not essential. Even if I say not a post which is permanently created but contractually filled up. So the post is permanent the moment the school says that it is a sanction, which is the government approves it as a sanctioned strength of teachers. No, that's the sole point. And the definition does not make any difference as such.
All right. And do you like to rely upon any precedents in your favor?
Substantive post may not the I can rely on regularization, but that will not ipso facto not directly apply in this case. Substantive post has not been defined as such in any law. The question is only with regard to the requirement of an establishment. But the moment the government approves that these posts are sanctioned for the purpose of renewal of recognition or affiliation, but it has to be reckoned as a substantive.
What have you annexed your exception to show
the
that
exception-
there are sanctioned vacancies and there is no teacher?
Only by way of an example, if your lordship will kindly come to page 18 of my supplementary affidavit.
Supplementary affidavit, yes.
Page 12, I'm sorry, page 12. I'm sorry, exception page 12. Not really, I'm sorry, not against. Please come to page 12. Please come to page 12 first.
Yes.
Of the exception. Not the type of institution, it's the fourth column from the top.
Co-education.
Yes, please see the heading, form for higher secondary subject permission request. Type of institution is co-ed, then renewal granted up to 30th of June 2028.
Yes.
Now please come down to the name of the teacher against the subject. He is a history teacher. And under the broad heading of subject paid for. He is a history teacher. Permission type is continuation. Category of teacher is part-timer. Then please consider this with page 20. Page 17. Page 17. I'm sorry, please come to page 17. Now, this is the school's portal revealing the subject teachers. Some of them are petitioners. This is the disclosure of the school.
Where is this Sushanta Sarkar?
নাম দেখা একটা জায়গায় না ওখানটা আসি এখানে পোর্টালে দেখা Oh, no, page 12 is the portal itself. That's the council's portal.
What is 17?
17 Lord is the list. Please come to page 16. This is for another teacher. To show that he has been appointed as an examiner.
No, that is different.
Yes.
That is different. What is page 17?
Page 17.
Total count, teacher designation, type, answer script evaluated.
This is not the teachers who have evaluated answer scripts. Please take page 16 and 17 together.
That means Shushanto Sarkar did not evaluate answer scripts.
Please come to page 16. I'm not there. I can document enclose korish ni. Please come to page 16 and 17. Oh, no, I'm sorry. Yes. Page 10, not yes, of course. Page 10 and 11.
Yes, examiner and scrutiner
Yes.
is there.
Yes.
No, but then what is page 17 and 18?
It's for another petitioner. Devashish Chatterjee, serial number 8 at page 17.
Same school?
No, it's a different school, Haridashpur High School.
How does all these parties come together in one writ petition? How do they join in? Where from do you get them? and they just club in one writ petition. Different candidate, different school, dates of appointment, different. In that case, there's so many writ petitions are not required to be filed. Only one writ petition throughout the state will be suffice.
Only one thing, that this is probably only for the purpose of a decision being taken as to whether part-time teachers as a whole can be reckoned or not. That's the sole point.
Yes.
I got your lordship's
observation. The issue as to whether the 2025 rules is proper or not. Let the entire state candidates come and file one writ petition. It's like this.
Different persons may have different causes of action to challenge, but not here. Not the single point is whether part-time teachers, in so far as the definition is concerned, I mean the concept is concerned, can be reckoned or not can claim this benefit.
And show me their advertisement and the rule where it is mentioned.
Not the rule has been annexed to the report.
Yes. You annexed it with your writ petition also.
It's also in the writ petition. Yes. Please come to not page 114.
Yeah, 114. I am there
at 124 and 125.
Right. Permanent and contractual. And you are part-time. All are part-timers.
Yes.
And their service is continuous.
Yes, but it shows that continuing.
That is only in respect of one. You've got how many petitioners here?
But all these have been annexed to the writ petition.
Yes. Have you prepared a chart from where it can be ascertained your date of appointment, your date of continuation, and part-time you say? Anything of that sort, so that you place it in front and you get to see how they have worked.
Yes. Subject wise and the schools.
Yes. So it becomes easy
at a glance.
Commission also.
At a glance.
You can prepare. You should have prepared it.
Should have been done.
Otherwise, how will you argue? They are part-timers. Nobody knows for how many days you work, maybe for 1 month or 2 months or 1 year or 2 years. Nobody knows.
All the documents have been annexed, not the initial letters and not the pay slips. Not these have been annexed, but not for the cursory observation.
Who pays you?
From the school fund.
Right. That means nothing to do with the district inspector of schools, your service.
Not in so far as the state stand is concerned, I have shown to your lordship paragraph 7. Even a
Bro, can I show you one document, just one document? Can you see page?
Let me see your report. Page.
Bro, can you see the page 28 of the writ petition? Can you see?
Yes, please.
So many candidates. See.
Yes, Raigram High School.
See, my lord, voluntary teacher.
What does this mean? Bona fide voluntary teacher? That means you are voluntarily giving service. The school is not willing to accept. You are going there on your own.
No.
What does this mean?
If this name features for the purpose of this has this expression voluntary teacher is there in GHC. No. Gorkha Hill Council. This matter has gone for months now.
No.
So the headmaster of the school is saying that you are voluntarily teaching. The school does not want your service. You choose to serve the students.
If I can, all these documents would show that they have been, the recognition has been renewed on the strength of these persons.
No, but then
I will prepare a chart just to show for the length of service and the remuneration.
But if this is voluntary service, you go and serve. Who cares?
No, these are all part-time teachers. No, I shall show from the document itself. The portal, from the portal itself.
All right, come up. Let us see. Please come.
All these DIs and schools should be made party here.
Yes, lots.
They should be made party. Higher Secondary Council also be made party.
The instant writ petition has been filed by 18 petitioners by depositing only 1 court fees. Stop. The advocate on record of the petitioners is directed to deposit the deficit court fees by 12th December 2025. Stop. The petitioners, paragraph D, claim to be part-time teachers in government-sponsored / government-aided schools. Stop. Did you all fill up the application forms? You will not get the prior teaching experience, but then otherwise you can participate.
Yes, we have.
The petitioners participated in the recruitment process for appointment of assistant teachers being conducted by the West Bengal Central School Service Commission. Stop. They seek marks on account of prior teaching experience. Stop. The issue to be decided in the instant writ petition is whether the part-time teachers of the government-aided / government-sponsored schools would be entitled to the marks meant for prior teaching experience in terms of the West Bengal School Service Commission bracket open selection for appointment to the posts of assistant teachers for upper primary level of classes. Third bracket, except work education and physical education, page 114. Third bracket close, comma, classes 9 and 10 and classes 11 and 12 rules, comma, 2025. Stop. The report filed by the commission and the exception thereto filed by the petitioners in court today be taken on record. Stop. The petitioners are directed to prepare a chart disclosing their dates of appointment, comma, the schools where they are serving, comma, and their tenure of service. Stop. Are the DIs parties?
No.
Who is going to satisfy whether you are working in a substantive post or not?
The district inspector of school lordship. All lordship are going to school.
That commissioner of school education can be.
No. Commissioner is not a lordship. District inspector of school, all lordships. School. Recognize. Commissioner is not a lordship.
Education department.
State has done this.
Lordship, I am in this matter, lordship.
The respective district inspector of schools shall be implemented as party respondents in the instant writ petition. Stop. The learned advocate representing the state respondents shall obtain necessary instruction from the respective DIs as to whether the petitioners are serving against substantive posts or not. Relist. How soon can you prepare the list? Start.
2 days.
The 16th of December.
Let's see, in the meantime, lordship, give me the supply, the copy, lordship. In the meantime.
Copy? Which copy?
Which that is cited before his lordship, where the petitioner is working.
All right. You give the list to Mr. Boisho so that he can take instruction from the respective DIs.
Lordship.
My lord, last second, my lord. Next matter, my lord, already, my lord, they changed the admit card. CBS.
Which one?
Evolution?
17?
18.
18. Please see. You got the marks?
Yes.
You were not present on the last occasion. No, he was also not present. Your junior was there. You got the marks? You are happy?
My lord, only my lord, I surrendered the marks, old marks sheet.
And they'll give you a new one.
Within
All right.
within a
Give me.
English theory paper.
95.
Initially, how much it was?
72.
From 72, she got 95.
No, 75.
75, 92 minus 95, my lord, total.
Yes.
72 to 75.
72 to 73 marks you got extra. Please come. The updated mark statement comes certificate of the petitioner disclosing that the petitioner has been awarded 75 marks in English language and literature by the Central Board of Secondary Education. Handed over in court today, be written with the records. Step. The grievance of the petitioner appears to have been redressed. Step. The petitioner is directed to return the old mark sheet, and the school is directed to hand over the petitioner the updated mark sheet at the earliest.
The board is directed to school to supply the new mark sheet.
This possibly is the original has been
Available on DigiLocker. The
Okay.
original one, my lord, it is with the board. Now
Oh.
they have to surrender the old mark sheet through school.
আচ্ছা তাহলে কি
Then
বললাম
board
ওটা?
will issue
The
revised.
petitioner is directed to surrender the old mark sheet to the school authority, who will thereafter forward the same to the board for obtaining the updated mark sheet.
And within a 1 month.
Stop. The updated mark sheet shall be handed over to the petitioner within a period of 8 weeks from the date of surrendering the old mark sheet before the school authority. How long will it take? 8 weeks is all right?
They will as expeditiously as possible. They will do.
At the earliest, but positively within a period of 8 weeks from the date of surrendering the old one. ঠিক আছে? Old mark sheet before the school
School
authority.
is not represented. My learned friend will communicate this order to the school as my lord.
Learned advocate for the petitioner shall communicate this order to the school authority for necessary compliance. Disposed. Item. Court fees paid. All right, then it is একটু check করে নেবেন 17 please see Shailesh. All right. হ্যাঁ যদি দেওয়া হয়ে থাকে তাহলে ওটা লিখতে হবে।
This matter, I am appearing for the school. Respondent number 5, I have a preliminary objection, my lord, with regard to maintainability of this.
Yes. Yes.
What is the matter about?
Yes, my lord. The matter about is the suspension of the principal of a private school. But in the meantime, there is a development that apply before the deputy director of a school, government of West Bengal. They have taken a step after receiving the writ. Kindly see.
State is there?
State, yes, my lord. Mr. Chatterjee is there.
Kingston Modern School.
Yes, my lord.
Does this bench have determination? Is it a
Secondary school, my lord.
secondary school?
Yes, my lord.
Model secondary school?
Yes, my lord. Secondary school.
Acha. There is a harassment of women.
Yes, also.
Rakhi Ganguly, she is a petitioner.
Yes, my lord.
Yes, what has happened?
That is the deputy director is the my lord respondent number.
No, what is your allegation that the petitioner was harassed?
Yes, harassed and
Sexually harassed?
also 3 yes, my lord. 3 months salary has been held up.
Is
That is, Malad, may I just
no
indicate?
suspension allows has been allowed.
harassment? What type of harassment? Sexual harassment?
Physical assault and by word.
Malad, that is not the subject matter of writ petition. Kindly see the prayer. My learned friends.
ICC has taken steps. That means it must be sexual harassment.
Malad, this is, my lord, we have not received, my lord, as on date, I do not have any instruction. But this is, my lord, the subject matter of writ petition. Kindly see the prayer. This has nothing to do with this issue. Seeking arrear salary and subsistence allowance. Now, my lord, why I said, my lord, this writ petition is not maintainable, my lord, she has been placed under suspension for two, my lord, allegations. First is huge financial irregularities. Second, my lord, maladministration. Now, my lord,
what is her designation?
She is the principal of the school, principal director. Now, my lord, she had shown, my lord, other students as, my lord, the students of this Kingston school, my lord, in order to obtain registration certificate from ICSE. This is the principal allegation. There are other financial allegations, my lord, but the question is,
who are you?
Service, my lord, I am the school, respondent number 5.
School represented by?
Represented by a society, my lord, respondent number 5.
Kingston Educational Institute,
Yes, this
having
is a
its
society.
corporate office.
This is a society, my lord, under West Bengal Societies Registration Act. The service condition of the petitioners are governed by a non-statutory regulation. We are not, my lord, receive any aid from the government. Now, your lordship knows, my lord, this issue is no more a res integra, my lord.
How is the writ petition maintainable?
Yes, my lord. That is the question, my lord. That several decisions are there by the Honorable Supreme Court. My point is that if there is a violation of natural justice and if it is a public function or duty of the institution, the mandamus can be invoked. And mainly, my lord, what is the alternate remedy? Now I ask my question. Alternate remedy is the civil court. But civil court has no contempt power or jurisdiction.
Contempt?
Yes.
Why are you going to contempt?
No, my lord, if the degree is passed, how the degree will be executed? That execution, 5 years, 7 years execution will be going on.
So civil
no
court
other
shall be stopped?
Yes, my lord. Let me submit, my lord, that no is a access to justice. That is 5-bench judgment. The Honorable Supreme Court, that the constitutional bench, my lord, that I am going to yes, access to justice. What is the remedy available or not? Yes, my lord. A citation is, my lord, the relevant
2016 8 SCC 509. Anita Kushawaha and Push-up Sudan versus Push-up Sudan.
There's so many matters, my lord, along with matters that 5-bench judgment. I am relying that access to justice under the Article 21, it will come, invoke the Article 21, access to justice. And the access to justice, not mere in the procedural law or in the private and or public law. That access to justice is to be available, and it will, if the access to justice is not remedy so speedy, efficacious, then alternate remedy is not barred, because it will come under the Article 14 and 21 and also 39A.
What are the other articles that you want to rely upon? You've said so many.
14, that equal protection of law in the law of the land. First is that will invoke Article 40. And Article 39A also here discussed, because the Article 39A, the delivery of justice system, even in the economic constraint, should not be way. For that reason, Legal Aid Services Authority has been passed.
Listen, do not give this type of submission. You say how the writ petition is maintainable.
Yes, access to justice, my lord. That page 530 para.
You access to justice there in the civil court also. You've got access to justice.
It's not a speedy judgment.
Are you okay with this? They have already taken steps.
Yes, my lord.
You are okay?
Yes.
What is the use of proceeding with the writ petition?
They have taken my prayer. Kindly see.
You may have a lot of prayers.
Arrear salary has been held up.
have a
And
lot of prayers. The issue has been taken by the district inspector of schools.
Yes, my lord, after the service of the writ notice,
All right.
that has has been a step.
So
Earlier
you
not.
proceed with the DI.
Yes, my lord, they can, but my lord, area salary should be released.
You make your prayer before the DI. Why will this court entertain your writ petition?
Otherwise, DI previously has not been DI. I think that, my lord, it is my assumption that DI will not take such a step. If your lordship is pleased to direct DI,
No, no, no. Certainly not.
my lord, relief. I pray for relief, my lord. Access, speedy relief, and access to justice is that
The petitioner claims
paragraph
to be
36.
a teacher of a private institution. Stop. She is aggrieved as she has not been paid salary for the last 3 months.
Yes, my lord.
Stop. Prayer has been made to direct the district inspector of schools to take steps for releasing her salary. Stop. Paragraph.
The DI has not been made part.
Not it is not a government sponsored school. How will the DI entertain? I do not understand.
My lord, the department also, your lordship will find.
I am surprised, my lord, to get this, my lord.
How the DI will entertain if this school is not affiliated to the state government, doesn't get any grant, no aid? How the DI gets in? I don't know.
I do not know, my lord.
Yes, but DI should be
Absolutely not
But the
understandable.
deputy director is a party, my lord.
Go to the deputy director and the director and to principal secretary, whoever you want to.
I pray just speedy justice.
It's just like instant coffee. You want. And
Litigant always
the court acts in that manner.
no, that litigant always pray.
To
Not as physical effort.
no, district is a direct the state respondents koro to take steps. ঠিক আছে? Learned advocate for the petitioner has placed before this court a communicating memo being number 705/G dated 26 November 2025 issued by the District Inspector of Schools, Secondary Education, Barasat, North 24 Parganas. Addressed to the Secretary and the Principal of Kingston Model School that an inquiry is scheduled to be held on 4th December 2025 in the school premises to inquire into the issue of harassment of women. Stop. Next. The school and the parties have been directed to cooperate with the inquiry team. Stop. Paragraph. It has been brought to the notice of the court that the school is run by a registered society. Stop. The same does not obtain any grant from the state government. Stop. The district inspector of schools, secondary education, has not been impleaded as party respondent in the instant writ petition. Stop. The respondents raise an issue with regard to the maintainability of the writ petition before the court. Stop. Paragraph. To allow the parties to revert with instruction, release the matter for further consideration on 5th January 2026. The issue of maintainability is left open to be decided at the time of on the next date.
My lord, just instead of 5th, 6th or 7th.
Why? What is the difference?
My inconvenience.
Your inconvenience.
The marriage ceremony in my home.
All right, enjoy the marriage. If the matter is taken up, your junior will be here. He can seek accommodation. All right.
Lordship, I'm for the petitioner. I'm led by Advocate Shobhusha Chatterjee. He is currently engaged in another court. Until he arrives, I will assist your Lordship in the matter. Lordship, the case in a nutshell was that the HRA overdrawn has been alleged against me, and on that reason, the ADR claim which I have filed have been withheld for a long time. Lordship, on last occasion when the matter was taken up, your Lordship had directed the District Inspector of School to come prepared with the written instructions.
Lordship, the written instruction is in this petition, in this case, your Lordship, they have relied
Give a copy to him.
They have relied upon a coordinate bench judgment passed by Lordship. That order has been carried upon in appeal. The appeal is pending, though there is no stay. Now, in similar matters, my instruction is, your Lordship, the coordinate bench have passed certain orders giving relief to the petitioners, but that may be that may depend upon the result of the appeal court order, your Lordship, is it is in MAT 102.
Please come. The District Inspector of Schools, Secondary Education, Howrah, has forwarded a report dated 27 November 2025, clearly disclosing that the spouse of the petitioner did not work in the government concern, as per the documents annexed to the writ petition. Stop paragraph. The DI has mentioned that the relief of giving full benefit of house rent allowance has been allowed in terms of the order dated 16th March 2021, passed by a coordinate bench of this court. Only to the teachers who have obtained specific judicial orders. Stop. Paragraph. It has been brought to the notice of the court that an appeal being MAT 1023 of 2021 against the judgment dated 16th March 2021, passed by the court in WPA 1389 of 2018, is pending consideration. Stop. The order of the coordinate bench has not been stayed till date. Stop. Paragraph. In view of the above, the claim of the petitioner to receive full benefit of house rent allowance has to be allowed in favor of the petitioner. Stop. The respondent authorities are directed not to recover any alleged excess house rent received by the house rent allowance received by the petitioner. Stop. Paragraph. The The this order is being passed subject to any order being passed in the pending appeal being MAT 1023 of 2021. Stop. Is there an impugned communication? Order?
Yes, Your Lordship.
Which one?
Your Lordship, I made a representation to the authority.
For what?
Your Lordship, before filing the writ petition, Your Lordship, P4 and P5.
That means there is nothing to be set aside.
Your Lordship, yes, Your Lordship. Yes, sir. Sorry, Your Lordship, I got it.
The communication made by the Assistant Director
Your
of
Lordship, that is
Accounts,
P5, page number 53.
Secondary Education, Howrah, dated 24th December 2024, stands set aside. Disposed.
Grateful, Your Lord.
Lord, Mr. Tonju Tiwari will appear on behalf of the petitioner, but we need some instruction. That for reason we need some more instruction. That for reason I am paying 1 week adjournment.
Commission was meant to come back with instructions.
Last part of the order.
Let me see.
80 to dot check with them.
What is it?
But these part-time teachers are asking for experience marks.
That means marks have been awarded to similarly placed candidates.
This is well, kindly turns to serial number 141. So they have
Page 9. Page 9. Page 9 of.
9. So they have taken the example of two candidates. One is Bishwajit Barik and one is Manoj Kumar Jana. Well, if 141 is Bishwajit Barik, current status says not in cutoff due to change of experience marks. Previous experience score 10, current experience score 0. So, for part-time teachers, we are
No,
not.
that means previously, did you allot 10 marks to the candidate?
They had given the experience years in the application form. Thereby, so on that disclosure, we had to allot 10 marks. So once they came for verification and when we checked the documents that he is a part-time teacher, we had to take away those 10 marks. So the commission is not allotting 10 marks to, even if previously given, it is being taken away.
What about Manoj Kumar Jana?
Manoj Kumar Jana, that is yet to be updated. So if he is found that he's a part-time teacher, then his marks will also be taken away.
The list of candidates found to be disqualified for interview and lecture demonstration after the verification phase, handed over by the learned advocate representing the commission in court today be taken on record. Stop. It appears that Bishwajit Barik, who the petitioner referred to, has not been awarded marks on account of teaching experience. Stop. The marks which was provided to him on his self-disclosure was found to be improper. Stop. The commission is yet to verify the credentials of Manoj Kumar Jana.
His verification is happening today.
Paragraph. To allow the commission to revert with instruction released next Tuesday, 9th.
Obliged to Lord.
Lord, in 21, my Lord, I am for the state respondents led by Mr. Boyce, who is in virtual mode, my Lord.
21, my Lord, I am led by Mr. Ujjwal Rai in this matter.
This matter, my lord, your lordship had granted us leave to file a supplementary affidavit.
Copy we served upon us.
Copy.
Yes,
My lord, let me hand over a copy of that.
yes, please. In that case, they will require time to come back. My lord. What is the matter?
My lord, the
Preliminary
issue here
matter
is that the petitioner
cannot be ascertained with the previous submitted. All right. What does it say? That you submitted objection at the first stage?
I did not, my lord, because I have said that the affectation of my right, the cause of action arose only after I saw that a question which was perfectly within the syllabus, they have given marks, 3 questions which were within the syllabus. The commission has awarded marks to everybody who has attempted it or otherwise. But in my case, my grievance is that there is a question in series D which relates to B.R. Ambedkar's founding of the Independent Labour Party, which according to my case is that this question was out of syllabus. And for that, my lord, I had addressed a representation after 10 because I had no idea that the questions which were within syllabus, the commission would grant everybody same marks. Because of that, I suffered prejudice. And after that, I wrote an email to the commission stating that this question number 3, as regards B.R. Ambedkar's Labour Party is out of syllabus. Now, my lord, I have also cited an example whereby after publication of the final answer key, my lord, Commission has issued a notification dated 10th November 2025, whereby marks has been accorded in respect of questions which were out of syllabus in geography. It's annexed to the supplementary affidavit. Yes, after the final answer key was published.
Was it? Copy extra nahi?
Sorry.
Ki re?
Would you like to come back with instruction? Please come.
I would like
Supplementary affidavit filed by the petitioner in court today is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the respondents in court today. Stop. To allow the respondents to revert with proper instruction, released on 16th of December.
It appearance. Deeply obliged.
Lordship, I am obliged, Lordship.
22, I appear for that is regarding 10 marks to the teachers of DA getting students. Kindly have a look to the last order minute. Now, the case of the petitioner is that I am a teacher of a day getting school unapproved. I am discharging my duty for last 12 years. Now, your lordship is aware that in the day getting schools, the appointment of the teachers are made by the school, approved by the DI, then only the DA component is released. Now here I am asking for 10 marks as well. Kindly have a look to page 63. In the written examination,
How much did you secure? 51.
51 out of 60, 85%. Now 10 marks will
take it to 61.
61. That I'll be within the zone of consideration. I am against a Hindi medium school. This is not Bengali medium. So, my simple contention.
There are vacancies.
Yes, 27 vacancies are there in the Hindi medium.
How many candidates are contesting for this?
That the commission has the information, I don't have. But if your lordship kindly says simple contention, the approval is given by the DI for DA, and the appointment and the board, West Bengal Board of Secondary Education, the board is the authority to approve the election of the managing committee. So, but the government has control over the school. It is not the case that the government has no control on the school. This is my case.
Yes.
But I'm on a simple point, that is the application form is missing.
Missing?
From the writ petition. It is not annexed. If there is disclosure of past teaching experience, those 10 marks given, regardless of the fact whether it's a DA getting school or it is not a DA getting school or it is anything, my lord. So when the verification, at the stage of verification, when he comes and he shows that there is past teaching experience, we check the credentials. Now it's left for us to see whether we are going to give it or we are not going to give it. But in the application form, Millard knows it. That
Where's the application form?
Well, I tell you, Lordship, well, I
Could
cannot
not fill up because the teacher
because
code was not there.
The teacher code was not provided.
And if the teacher code is not there, can you not fill in how many years service
I
you
cannot. But
have
the teacher
rendered?
code needs to be supplied by the school. And that is why, my lord, the last order was passed by the school. A copy has been served on my learned friend to seek instruction from the DI.
So he could not fill up the application form. And he admits that he could not fill it up because he doesn't have the teacher code.
We'll check the application form we have.
I admit that I could not.
Yes, that is recorded in the earlier order also.
But on the last occasion, your lordship was pleased to direct me, my lord, to take instruction, my lord, whether, my lord, the school is a DA, my lord, he is the approved teacher or not, my lord.
So he says he is not an
I'm not.
approved
Not
teacher.
approved teacher, my lord.
And is he working against any sanctioned vacant post?
He is not working against any sanction post.
একটু দেখবো
হ্যাঁ নিশ্চয়ই কেন
How is she teaching?
In a DA getting school, it is permitted. In a DA getting school, it is permitted.
So after this, can you, do you have any claim?
I cannot.
But I have just received instruction that teacher code is not mandatory. Many have filled without.
No, but then if you go on changing your stand, how will the candidates get to know whether it is mandatory, not mandatory? If there are fields, it has to be filled up. Then?
But for us to give the prior teaching experience marks, only thing is required is the prior teaching experience number of years to be disclosed.
Irrespective of the fact whether the candidate is teaching against a sanctioned post or not?
So when they disclose, we give it. Then during the verification, when we see that they are not against a sanctioned post, we take it.
What does it mean? You give and take, it means nothing.
That is how the workings of the
No, that is not
rules
the
are.
proper way of functioning. The teachers, the candidates who are applying should know as to what exactly is your nature of functioning.
So then Malad kindly takes up the rules which they have annexed at page 28. And this would be schedule 2, A2, then Malad B, prior teaching experience 10 marks. It is clearly stated here that at the secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post. Permanent or on
See,
a
this argument has been made on a number of occasions. The court will not spend any more time. Please come. From the
And in a
report
substantive
forwarded by
post
the
as permanent or on contractual basis. So, my lord, if my appointment is on contractual basis also, if your lordship sees my appointment letter,
such and such, dated such and such, it appears that the petitioner is not working against any sanctioned vacant post in the school. Stop. The requirement of the rule pursuant to which the selection process is being conducted requires teaching experience in a substantive post as permanent or on contractual basis. Stop. The District Inspector of Schools does not mention that the petitioner is working against any substantive post. Stop. Next. In view of the above, the prayer of the petitioner for awarding marks on account of prior teaching experience cannot be allowed. Stop. The writ petition fails and is hereby dismissed.
Well, may I only show to your lordship at one page? Before
What will you show?
let the till this month I receive salary from the school.
Yes, they admit it.
Yes, then but substantial or contractual. But if I am on a contract basis post also, but for last 14 years I am discharging my duty. Kindly have a look to Joseph petition.
No. Please, I'm not going to reopen. You try to see if the appeal court is in your favor or not.
Appeal?
Please try and see. There are matters where the appeal court is interfering and passing orders.
I'm here before your lordship. Kindly
I
give me
cannot.
1 minute time to satisfy.
Please call. Yes.
But it is not possible for every client to go up in appeal.
I understand very much. And keep an eye as to what happens to the rules because they are under challenge.
Very.
Yes. 22.
And for the statement.
Yes, please.
Lordship, this is a writ petition praying for a Lordship the pension of the to the unmarried daughters.
Yes.
Lordship, there are two daughters. One is the elder, I am the younger. This court directed the Lordship the elder daughter to be a party as an added respondent. I have added and also directed to file an affidavit exonerating her claim that if the Lordship the unmarried daughter's pension is disbursed, she has no objection. Also, I've received the copy of the affidavit. Now, Lordship, my claim, Lordship, this is admitted fact that unmarried daughter at present entitled to get the pension. Lordship, there is no dispute. Now, here is the dispute is what is the limit of income. Now, Lordship, my application has been rejected that and observing that my annual income is 60,000 per year.
Which page?
That is page 109.
All right.
Although, Lordship, I had disputed my income is not 60,000. Now, the government of West Bengal, Lordship, reliance upon the notification of the State Finance Department, issued a notification in 2023 that the income limit of the unmarried daughter from 3,500 per month to 9,000 it has been extended. And to that extent, an order has also been passed. Yes, this is secondary education, Lordship. They kindly come the last page and the order. In terms of the memo dated such and such, the Finance Department Pension Branch has raised the income ceiling for entitlement of the family pension of the state government employees and pensioners, respectively to rupees 9,000 only per month. As per the order dated 21st August 2023, such and such, the proposal for raising income ceiling of unmarried daughters only of teaching and non-teaching employees, pensioners of government, non-government aided education institution West Bengal from 3,500 to 9,000 only per month for entitlement of the family pension. After careful consideration of the matter, the governor has been pleased to decide the income ceiling of unmarried daughters only of teachers and non-teaching employees of the pensioners non-government aided education institution West Bengal be raised from 3,500 to 9,000 only per month for entitlement of family pension, and this will immediately effect from the date of issuance of order, and other terms and conditions shall remain the same. Now, Lordship, subsequently, the widow and Lordship, kindly come my notification of annexed in the that is page 117. The widow.
Well, this is of 2023.
Yes.
Right.
Yes.
Your rejection was prior to this.
Yes.
Right. So let them consider it afresh.
In terms of this.
Right?
My lord, one more thing, my lord. My lord, the other ground of rejection was the fact that there was an elder daughter,
No, that
elder sister,
come by way of
by
an
way of an affidavit. Just two things, my lord. As per the rules, kindly comes to page 114, my lord, of the petition.
Yes.
First clarification against serial number 2. When the deceased government employee has more than one divorced widowed daughter, family pension shall be payable in order of the date of birth, and the younger of them will not be eligible for family pension unless the next above her became ineligible for grant of family pension. Thereafter, my lord, the next page again.
How does this help you?
I'm unmarried.
My lord, my lord, may I place the next page, my lord?
All right.
Next page, my lord, the last 3 lines of the penultimate paragraph.
All right.
Grant of family pension to unmarried, widowed, divorced daughters shall be payable according to their date of birth.
It's the same thing.
Yes, my lord. And if my lord sees the impugned order, which is at page 109, at page 110 it is written that one's eligibility can't be transferred to another. So they have followed those rules and they have said that this cannot be transferred. But my instructions are, my lord, that since the income ceiling has been raised to 9,000, if they submit the fresh income certificate and the legal age certificate, might I produce my instructions, my lord? My lord may see the second page.
Please come. The prayer of the petitioner for grant of family
May be considered,
pension
my lord.
in respect of widow,
Unmarried daughter.
unmarried daughter. Widow হবে না, unmarried daughter of a teacher of a secondary school.
Yes, teacher.
Aided, government aided.
Government.
Government aided secondary school. কি দিয়ে শুরু করেছিলাম? Yes, was rejected by the district inspector of schools, relying on the memo being number 95 within bracket 80-SE, page 109, within bracket caps B, dated 13th April 2010. And also, as per GO number 432-F within bracket pen, dated 2nd July 2008. Stuff. It has been brought to the notice of the court that the income ceiling of family pension has been raised by the government by memorandum being number 1613. Please copy. Dated 9th November 2023. Stuff. Next. The petitioner has an elder unmarried sister, right?
Unmarried daughter.
Unmarried sister.
Unmarried sister who is eligible for receiving the family pension. Stuff. The said unmarried elder sister has disclosed her intention not to accept family pension. Stuff. She has also disclosed that she does not have any objection if the family pension is awarded in favor of her younger sister, who is otherwise eligible to receive the same. Stop paragraph. Learned advocate representing the state respondents relies on the communication made by the District Inspector of Schools, Secondary Education, Hooghly, dated 4th September 2025. Has disclosed that the In the family income ceiling limit has been raised. Are you aware there is another memo, 2024 memo, School Education Department? You are relying upon 23 memo.
Yes, 24 memo I have also annexed,
Where?
117. That is in respect of divorce and widow daughter.
117. 29,720. That is in respect of
Divorce and widow.
divorced and widow daughters.
That is also 9,000.
ঠিক আছে তাহলে ওইটা হবে না মানে যেটা বলেছিলাম সেটাই হবে has been raised and the petitioner would be entitled to receive family pension. Stuff. The district inspector of schools request the petitioner to submit all her documents, including the heirship certificate and income certificate from the competent authority, so that her prayer for issuance of family pension may be processed. Step next. In view of the above, the instant writ petition stands disposed of by observing that it will be open for the petitioner to submit all required documents to the District Inspector of Schools, Secondary Education, Hooghly, so that the same may be forwarded to the DPPG for issuance of family pension in her favor. Step. The District Inspector of Schools is directed to make a formal communication to the petitioner disclosing the documents that she is required to submit at the earliest, but positively within a period of 4 weeks from date. On receipt of documents from the petitioner, the DI shall take necessary steps to proceed with the same in the light of the prevailing memorandum for grant of family pension in favor of unmarried daughters. Disposed.
Kindly direct them to proceed with the certain period.
Within 4 weeks, a communication will be made to you regarding the documents that you are required to submit. You will submit it and they will proceed with the same.
And also let the impugned order be also questioned.
The impugned order dated?
Lordship, that is 17th February 2023.
17th February 2023.
And 8th November 2023.
Where is it?
That is page 111.
Oh. And the subsequent order dated 8th November 2023
Lordship,
are set aside.
Lord, I appear for the respondent number 5 to 9.
Yes.
Your Lordship will find on the last occasion.
I beg to withdraw the petition because it suffers from the lack of want of jurisdiction, my lord. And I seek to file the same before appropriate forum.
Yes, but that was my preliminary point.
Petitioner submits that the petitioner does not wish to proceed with the writ petition before the High Court. Stop. Prayer has been made to permit the petitioner to withdraw the same and to move the competent forum for necessary relief. Stop. Next. In view of the above, The writ petition stands dismissed as withdrawn. Stop. It will be open for the petitioner to approach the competent forum on the self-same cause of action in accordance with law, if so advised.
Grateful.
I'm for the petitioner led by Mr. Ibrahim Sheikh. My lord, I'm praying for not today only, my lord.
Only problem, not today I'm not opposing. Only problem, the matter relates to the circuit, because we are matter.
How is it here?
I do not know. It was moved.
Yes, district Coachbihar.
District Coachbihar. So, it should be placed before the circuit.
Kindly make this not today, my lord, only.
In the writ petition, it is mentioned district Kolkata. I do not know.
My lord, I am appealing on behalf of state, my lord.
Where did the cause of action arise?
The institute is the Coachbihar. Director of Mass Education, Kolkata.
You want only not today? All right. The learned advocate for the petitioner pays for accommodation. Stop. According to the private respondent, this court does not have the determination to decide the issue. Stop. The matter relates to the circuit bench of Jalpaiguri. Stop. Paragraph. Let the matter appear in the list on fourth under the heading to be mentioned.
It be obliged, my lord.
Grateful, lord.
My lord, in item number 25, Mr. Firdaus Samim appearing for the petitioner. Today he is appearing before the Honorable Apex Court. Kindly make it not today.
There are so many advocates assisting him, and even then you want not today. Yes. Very well, not today.
Great.
Which 26.
I am here on behalf of state. I am led by Mr. Advocate. 26 is.
Was any order passed? 26.
No, yes, Your Lordship. Your Lordship, we are filing a affidavit. I will hand over the affidavit in the item number.
And did you serve copy? No.
We thought we would serve.
Serve copy. Give. Affidavit in opposition filed on behalf of the state. Filed in court today is taken on record. Stop. Let copy of the same be circulated. Stop. None appears on behalf of the petitioner. Stop. কোনটা আজকে
My lord, it is 26 item number.
Yes.
For the petitioner, my lord, I laid by Mr. Sudipta Dasgupta. Kindly short pass over, my lord.
He's coming.
He's coming, my lord.
Let him come. Appearing at
The copy.
copy. You collect the copy, right? And is it regarding the challenge to the rules or something? Slowly, don't fall down.
Who points are involved in this matter, my
An affidavit has been used by the state. Would you like to go through it and come back?
lord? The only thing here, argument, my lord, I will file. There is no reply because only 2 point of law is involved, nothing on facts, my lord.
All right.
I need not to file any reply.
All right.
My lord, 2 points are involved. Primarily, first point is when these 10 marks are to be awarded. At what stage? Before interview or after interview?
All
Which
right.
is one point, my lord.
Hmm.
Taking the rule to be valid, I have filed this petition taking the rule as a valid.
Yes, yes. Hmm. Right.
Two, 2L of the rules, my lord.
Hmm.
Your lordship kindly comes at page 27.
AGM.
My lord, so lordship kindly comes to page 27.
Hmm. Hmm. একটা কেন অনেকগুলো ক্যান থাকবে yes কোনগুলো ডিসপোজ হয়ে
Effect of SLST flexible selection test means in case of post, a list of candidates prepared category wise on the basis of the merit, which shall mean in addition to what has been stated in rule 2K, marks obtained in oral interview, lecture demonstration and prior teaching experience, and shall include the eligible candidates who have appeared for interview. So my lord, interview marks, after a candidate appears for interview, he obtains certain marks. Thereafter, my lord, the selection committee will consider the written marks, the interview marks, lecture demonstration marks, and the prior teaching experience marks, not before the interview.
all right yesterday this was argued extensively.
One state. Another thing, my lord, and I would like to place paragraph, the Supreme Court judgment for this point, my lord. My lord, first come to paragraph 20 of the Supreme Court judgment at page, my lord, 110. My point is, my lord, very short. 2016 candidates, my lord. If the rule is valid, prior teaching experience marks is valid, who will get this prior teaching experience marks? My lord, 2016 candidate, I say, are not entitled to get any marks for prior teaching experience. Why? My lord, paragraph 20, first I am reading. In our opinion, this is a case wherein your lordship has got that 100.
Yes, yes.
The entire selection.
Yes, you say, I can remember your submission that as the entire selection process has been set out not accordingly, they cannot get any benefit, and the court has also clarified that they will not get any benefit.
Not only set at not, my lord, it has been, my lord, there is a distinction between, if the Supreme Court said the appointments are declared invalid, that means, my lord, the selection process is good, appointments are invalid. Here, my lord, the selection process has been declared null and void. The appointment flows from the selection process, my lord. Once selection process is declared null and void, any appointment made therein, there cannot be, my lord, any experience gained from that.
All
This
right.
is the 2 points, my lord. Only.
All right, please.
My lord, your lordship, keep this matter tomorrow, my lord.
If it were in opposition, filed on behalf of the respondent numbers 1 to 3 in court today is taken on record.
My lord, commission has not filed any affidavit.
No, 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 no. Because it is the state's rule,
Yes.
and that is the reason possibly state has filed the affidavits defending their stand.
But my lord, it is the state's rule, but the implementation is being done by the SSC. So SSC ought to have filed an affidavit because the marks when it's to be awarded is being done by the SSC, not by the state.
The state says it will be at which stage the commission will follow. Acha.
All amendments are accepted.
Is the applicant in CAN 4 present in this matter?
কি করেছেন?
Mr. Partho Sarathi Boyal.
এটা most probably Mr. Dhar was appearing.
Oh.
No, এই আলী হাসান আলমগীর most probably. আলী হাসান আলমগীর এই একটু ফোনটা বলো তো 14 তে আছে 14 তে আছে Well, I'm just
All right. CAN 4 also appears to have been allowed.
allowed.
Yes. এটা কি করে বাইরে থেকে গেল বলুন তো দেখি এখন অন্যান্য ক্যানগুলো তো এখানে রয়েছে list the matter tomorrow.
My lord, only one thing, since your lordship has allowed this scan for, my lord, your lordship may be kind enough to direct the department to amend the cost total. Otherwise,
Yes. Otherwise, it will be a problem. In that case, tomorrow it cannot be done.
but not tomorrow, but it will, since it will.
All right. ঠিক আছে. The department is directed to amend the cost title.
তোমার এটা কি allow হয়েছে?
Yes, CAN 4 has been allowed.
সব ক্যান অ্যালাউ হয়েছে।
Cost title of the writ petition by impleading the applicants as party respondents in the instant writ petition stuff. It will be open for the applicants to file affidavit.
No, my lord, in this matter, we didn't file any.
You want to?
My lord,
You oppose all matters.
my lord, in Lubana Parvin's matter, we have filed an opposition, my lord, covering all the points. Since the virus was challenged in that matter, my lord.
Here's the point of
In that matter also, my lord, the 10 marks was challenged.
Here it is not the 10 marks. Here is the stage of 10 marks.
Well, we shall file opposition.
কি বললাম?
It will be open for the applicants to file affidavit.
হ্যাঁ থাকবে It will be open for the applicants to file affidavit in opposition to the writ petition stuff paragraph. List the matter tomorrow. কালকে থাকুক দেখা যাক Yes, next. না হবে না এটা থাকুক এখানে এটা ডিপার্টমেন্ট করে দেবে
I'm for the petition.
And for the statement.
I am paying interest on gratuity and ADA pension, Lordship. In this matter, husband has come before your Lordship.
All right.
Died in harness. Died in harness on 26th November 2019.
Yes.
And the PPO issued on 1st of December 2022 and I received the amount on 19th of December 2022. Wife was an headmistress, Lordship.
Interest on gratuity.
Interest on gratuity and ADA pension.
Died in harness. How can you get interest on the delayed payment?
Lordship, died on 2019, Lordship, and PPO issued on 2022.
Yes. And you want it from 19?
I want it from 19 to payment.
2022. So the authority will know which date the teacher will die. Huh? What yes?
Lordship, in PPO, Lordship, the date of death is mentioned, Lordship.
Obviously. So where is the delay? Had the employee retired, then there is a date that such and such person will retire on such and such date and the papers are made ready. But died in harness means he was in service and the person died. How will the authority prepare the papers? How can you expect the authority to grant you the interest?
Lordship, then kindly make it not today, Lordship.
Only not today. All right, not today.
And for the petitioner, Lordship, this is interest on gratuity and arrear pension on revised PPO, Lordship, under OPA 2019.
Who has signed this writ petition? The petitioner himself?
Lordship.
He has signed?
Lordship.
Will he be able to come to court and sign it?
Lordship. He's come, Lordship.
He has come?
Lordship.
Tell him to come. All right. The petitioner claims interest on account of delayed payment of his revised terminal dues. Stop. The petitioner is directed to, when will he come?
Lordship, kindly after vacation, Lordship, fixed it. After
vacation? Why? You want order today and you want him to come after vacation?
Lordship,
Why?
I have communicate, Lordship.
How long you'll communicate over phone?
Lordship, then kindly 1 week time, Lordship. 1 week, 15 days time, Lordship.
Today is Tuesday. Next Tuesday he'll come.
Lordship.
The petitioner is directed to appear personally in court on 9th December 2025.
And for the petition, Lordship. So interest on gratuity and arrear pension on single people. No.
The PPO was issued in May 2021.
Lordship. I received the amount 2022, Lordship.
You received the amount in 2022?
4th of January 2022.
Show me the proof. Where is the proof?
Not annexed, Lordship.
Then?
Kindly grant me leave.
The petitioner seeks interest on account of delayed payment of his terminal dues. Stop. It appears that the petitioner retired from service on 31st January 2021 and PPO was issued in his favor on 17th May 2021. Stop. According to the petitioner, the writ petition has been filed on 28th October 2025. Stop. The learned advocate for the petitioner submits that the amount mentioned in the PPO was actually disbursed in favor of the petitioner when?
On 2022, 4th of January 2022.
On 4th January 2022. Stop. There is nothing on record in support of submission of the submission that the amount was received in January 2022. Stop. Learned advocate, the petitioner is granted leave to file supplementary affidavit to show the date of receipt of the amount mentioned in the PPO. Stop. Supplementary affidavit shall be prepared and circulated. How soon? Next week?
Next week.
By 9th. Release the matter on 11th.
And for the petition, Lordship. Interest on gratuity and arrear pension died in harness, Lordship, on single PPO.
Come prepared, died in harness.
Lordship, kindly grant me time.
All right?
Not today.
Not today.
And for the petition, Lordship, interest on gratuity and area pension on single PPO, Lordship.
When did you receive the money?
On 2022, Lordship. But I'm not annexed, Lordship.
Not annexed.
Not.
This also you received on 4th of January?
Lordship.
Please come. The petitioner claims interest on account of delayed payment of terminal dues. Step. The petitioner retired from service on 28th February 2021 and PPO was issued on 16th May 2021. Step. The instant writ petition has been filed on 28th October 2025 disclosing that the amount mentioned in the PPO was disbursed on 4th January 2022. Step. There is nothing on record in support of receipt of the amount disclosed in the PPO. Step. Leave is granted to the advocate on record of the petitioner to file supplementary affidavit disclosing the date of receipt of the amount mentioned in the PPO by 9th December, released on 11th.
And for the petition, Lordship. Interest on gratuity and area pension under ROPA 2019. Service. Aget data. Huh? আগেরটা নেননি?
ROPA 19 benefit?
Lordship.
When did you receive it?
And received on 4th of June 2021.
Please come. The petitioner seeks interest on account of delayed payment of benefit under ROPA 19. Step. The PPO, the revised PPO under ROPA 19 was issued on 24th May 21 and the petitioner avers to have received the amount on 4th June 2021. Step. Next, the instant writ petition has been filed on 28th October 2025. Step. The petitioner is directed to remain personally present in court on 9th December 2025. Let the petitioner come.
And for the petition. Interest on gratuity, Lordship, on single PPO.
Please come. Interest on gratuity dismissed on the ground of delay. ঠিক আছে? Dismissed.
My petition, blood. This matter relates to awarding 10 marks. The main issue is pending. In the meantime, last occasion they have submitted a so far senior secondary is concerned.
Submitted?
So far senior secondary is concerned, they have awarded marks.
Right.
Now, so far secondary is concerned, they are yet to take a decision. And if they proceed with the selection process, in the meantime, let them award marks subject to the final outcome of the main writ petition.
Has your credential verification taken place?
Not yet.
Not yet.
Not yet.
Did you disclose your experience?
Yes, I have.
Then how do you anticipate that they will not give you marks?
But because I did not provide teacher's code and
All
roll
right, so you
number.
are not
But in my supplementary affidavit,
timer or a
No.
contractual or what? Where are you teaching?
part time led.
Part time.
But it is not in my supplementary I have disclosed that this document
Hmm.
which is available in the website of the secondary education department. Supplementary document. Like, here they can find everything, all details pertains to me.
Hmm.
Page number. সাফ করেছো?
Date of joining, the petition,
And everything is there. Date of joining, the school particulars. কোথায় date of joining?
Did you get a copy of the supplementary?
দিয়েছে।
No.
Which?
Yes.
এক নম্বর থেকে যাও, এক নম্বর থেকে।
He gave him 10 marks for his experience. And that qualification he got 10 marks, for experience he got 10 marks. So his total became 62. And cutoff is
70. So he doesn't qualify. Right.
In the spirit of higher secondary or secondary?
Higher secondary.
No, it's for higher secondary. 11, 12. 10 years secondary. So for secondary is concerned? That's my answer.
No, here it is only the secondary level, you say.
I now I pray for secondary level.
In respect of all.
Yes. So for yes.
Out yet means? All right. The result has been declared. All right.
Everybody is not eligible, they have not got it. So whereas 11, 12 is
No, they right now they do not press because they have seen that they are not eligible. Even adding 10 marks will not take them up to that eligibility. So no use pressing for the 11, 12s. All right, please come. The petitioners seek marks on account of prior teaching experience for their participation in the recruitment process for appointment of assistant teachers in the classes level 9 and 10. Stop. Learned advocate for the commission seeks time to revert with instructions. Stop. On such prayer, next Tuesday will be all right. Released on 9th. Supplementary affidavit filed on behalf of the petitioners. Be written with the records.
It was for gratuity and arrear pension and on single plan.
Gratuity and
Arrear pension.
what does it say? First of February 24. One minute. From the e-pension portal on the history of status against the application associated with the pension period, the petition are applied online application because the concern is the this is voluntary retirement. You do not know. You have not disclosed it either. Please come. The petitioner prays for grant of interest on account of delayed payment of her terminal dues. Step. From the EPPO, it appears that the petitioner retired from service on 1st February 2024 and the EPPO was issued on 28th April 2025. Stop. Learned advocate representing the state respondents has obtained instruction from the District Inspector of Schools, Secondary Education, Jhargram, wherefrom it appears that the petitioner obtained voluntary retirement. Stop. Her application was considered by the school authority and she was permitted to retire voluntarily with effect from 1st February 2024. Stop. The petitioner submitted her application for obtaining pension in the e-pension portal on 4th January 2025. Stop. Her application was thereafter processed and PPO has been issued on 28th April 2025. Step. It appears that there is hardly any delay in the issuance of the PPO in favor of the petitioner. Step. Next. In view of the above, the prayer of the petitioner for grant of interest on account of delayed payment cannot be allowed. The writ petition fails and is hereby dismissed.
I am for the petition.
Yes.
Interest from gratuity, Lordship. Widow has come before your Lordship. Died after retirement.
Please come. Widow has approached. Dismissed on the ground of delay. Dates গুলো বসিয়ে দেবেন। না নেই ডিলে বলে আমাদের যেটা আছে সেটা দেখবেন তাতে পেয়ে যাবেন নেক্সট All right, not today.
For the petition on last occasion, we have informed that passed away. So we have managed to obtain the death certificate given by the Diamond Harbour Government Hospital, my lord. They applied for government certificate, but it's pending.
You have applied for?
The certificate from government, my lord, death certificate. My lord, hospital certificate has been given, my lord.
You want the proper certificate from the authority?
No, my lord, we will obtain that. My lord, our prayer was that we wanted to rescind the suspension order, my lord, because there is indefinite period
No,
of suspension.
right now the person has
yes.
expired, so the
Yes, my lord.
suspension does
My
not
lord,
remain.
one thing remains, my lord, we have prayed in our writ petition, my lord, also.
The benefits.
The benefits and, my lord, the suspension allowance, my lord, substitution allowance.
You didn't get it?
My last 6 months, I am not getting it, my lord.
Who's for the school? 14 lakhs kept by the
Yes, that is the
The
fact of
person
the
has
case.
expired. So there is no chance of recovery of the money from that person at least. Right? Subsistence allowance will not, why will it not be paid? Who is for the school?
Well, we have served, my lord.
Yes,
Yes,
yes.
petitioner has expired.
The employee has expired. Teacher.
Nothing remains, my lord. Well, at least
Subsistence allowance, please come. The the sole writ petitioner has expired.
Application for a substitution.
On 17th November 2025.
এটা আমাদের না কাদের দিচ্ছে সেটা
Stop. Paragraph.
পড়েছিল জানি না এটা
Learned advocate representing the petitioner submits that the claim of the petitioner with regard to pending subsistence allowance still remains. Stop. Paragraph. Leave is granted to the advocate on record of the petitioner to take proper steps for substitution of the deceased. Stop. Do I delist it?
yes my lord.
Let the matter be delisted for the time being with liberty to mention.
Yes. In the meantime I will substitute the
steps
legal
for
error.
substitution.
Wait.
One answer the petition. This is interest for arrear pension. Matter pending before the division bench. Similar matter, similar. Lordship, similar matter is 41 to 44.
1 minute. 41. Record an order, please. The issue in question is submitted to be pending before the Honorable Division Bench. Stop. In view of such submission, release the matter in the combined monthly list of February 2026. Same order will go down in 42,
43,
43, 44.
and 46.
46 also?
46.
And 46.
45.
Yes. Give your appearance, please. 45. Let me see the brief ones. Is the service complete?
The service is complete, ma'am.
Let me see the affidavit of service. What is the matter?
Delay payment of interest. Delay payment of interest, ma'am.
Delayed payment of interest?
Yes, ma'am.
Interest of what?
Let me go to the facts. Petitioner was the headmaster of taxi.
I do not want the name of the school. What is your prayer?
Read in the nature of mandamus.
Affidavit of service filed in court is taken on record. None appears on behalf of the respondents. To allow the learned advocate for the petitioner to come prepared, release the matter in the combined monthly list of January 2026.
Lordship, I'm for the petitioner, Lordship. Lordship, on earlier occasion, your Lordship was pleased to grant leave to add the patent law of the petitioner. I have already implemented them, but the service has not been effected till date.
Why? Why did you not serve?
That's why I have already served. But the service is not effective till date.
When did you put it to post?
Yesterday.
Yesterday.
45.
Service upon the private respondent is not complete. List in the combined monthly list of February?
January.
January 26. Service in the meantime.
I am appearing on behalf of the petitioner last
Yes.
section. Your Lordship was pleased to direct me to serve a copy of the application upon the learned commentary. Accordingly, I have served a copy.
You served?
Yes. Actually, the petitioner obtained a higher qualifications. Initially he joined our service as a BSc honors in botany subject. Subsequently, she acquired higher qualifications according to rules. Petitioner is entitled to get the benefits.
Show the rules.
Actually, I have your Lordship kindly come to page 12, page 8, page 8. Page 10. That is, petitioner says that section 43 of the Control Expenditure Act 2005 provides inter alia that every teacher of a school shall, if appointed in the honors graduate or postgraduate teacher category, be entitled to draw pay of postgraduate teachers category upon acquiring postgraduate degree in the manner as may be specified by the order. And she was appointed.
Tell me, is there any representation from you for?
They have not taken any steps.
Where is that?
Last annex.
This is from the school. Please come. The prayer of the petitioner seeking higher scale of pay forwarded through the school authority is pending consideration.
DIF is the author.
Forwarded through the school authority is pending consideration. Step. None appears on behalf of the respondents. Step. In view of the above, the instant writ petition stands disposed of by directing the petitioner to forward a fresh representation annexing the copy of the representation of the school dated 20th June 2025 to the District Inspector of Schools, Secondary Education, Noida. Step. In the event the petitioner files the representation along with all documents in support of her claim, then her prayer for grant of higher scale of pay shall be considered by the aforesaid respondent strictly in accordance with law and the prevailing guidelines at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. An opportunity of hearing shall be granted to the petitioner for relying upon all documents in support of her claim. A reasoned order shall be passed and communicated to the petitioner immediately thereafter.
She is the authority.
Very well.
Representation was my lord. Teacher in charge.
And not today.
It is true. Well, 50 I appear on behalf of state respondent.
But 50 I am for the petitioner. But on last Friday, it was directed to be listed on 8th. The petitioner is a part-time teacher, claiming the marks for his teaching experience.
I am appearing for the commission.
You want it to be on the 8th? Very well. I'll list the matter on 8th.
It's a vocational teachers matter.
Yes, part-time vocational teachers.
Is it fixed on the 8th or the 10th or what? 8th?
Yes, some of the vocational teachers matter are fixed on 10th, some are fixed on 8th as well.
Vocational teachers matter fixed on 23rd.
23rd?
There are different matters, Miller.
Yes, they are coming in batches, so I cannot fix a particular date.
The vocational training methods, my lord.
Yes, yes. 23rd? Acha.
Kindly fix it on
You are a
23rd.
vocational teacher?
Yes, my lord. Part-time vocational.
Acha. The petitioner is a part-time vocational teacher. Stop. He participated in second SLST and he seeks marks on account of prior teaching experience. Stop. Whether the prayer of the petitioner will be allowed or not has to be decided. Stop. Released 23rd December.
But next matter is EWS. I'm told, tomorrow the matter has been fixed, my lord.
Similar matters have been dismissed on EWS category, my lord. Your lordship have
Tomorrow,
passed orders.
yes.
No, my lord, it has been dismissed. Item number 2, WPA 25640 has been dismissed by your
It has
lordship.
been dismissed.
My lord, in this case, the certificate was issued on 23rd September. In the matter which was dismissed, the certificate was issued on 10th of September.
Give me the case number.
WPA 25640 of 2025, my lord.
Take note. Come back tomorrow. All right. Not today.
Hey, number to bolte hobe.
52, my lord, I am for the petitioner. This is overdrawn died in harness widow. Your lordship asked me, my lord, is it possible as a widow? My lord, I have got take instruction from my client that the excess salary was drawn due to fixation, my lord. This is the letter, my lord, issued from the school, and this is the DPPG observation from 2004 to 2023. 19 years, my lord. This wrong fixation of pension has been given.
Right. And the person died in harness.
Died in harness.
Right. So if there is
Even after, my lord, the death, the employer-employee relationship goes. After the death.
Certainly.
So naturally, after 1 year of death, my lord, whether the respondent can recover the amount, my lord, I am that.
Thing is, the employee had certain years of service left.
Yes, I have given the death certificate. Yes, at the age of 52 years.
So he had 8 years of service left.
Yes.
The authority could have taken
That is assumption, my lord, 2004 to 2023.
assumption, presumption, nothing. But then how can the court pass an
Court
order?
has passed orders, my lord.
Show me.
Today
Where it has been decided. Come ready.
Yes, ma'am.
Take it back on the prayer of the petitioner. Who is for the state?
My lord, in last occasion.
None appeared.
None appeared. Very well, I will serve get notice.
I don't see anybody's name. None appears on behalf of the state. Stop. Learned advocate for the petitioner seeks time to come prepared. Stop. Released in the common monthly list of January 26.
My lord, may I file a supplementary affidavit indicating this? As you lord.
I am appearing for the commission in 53.
Commission, what is the matter about?
This matter, my lord, is about the petitioners are untainted teacher. They are challenging the award of 10 marks to contractual teachers. Mr. Anindo Lahiri moved one similar matter yesterday, my lord.
Right. Yesterday, today it was taken up.
Today his matter was regarding
tainted teachers. Right.
Yesterday he made submissions that contractual teachers who have been appointed through backdoor entry, they cannot be given 10 marks. They are untainted teachers, they should only be allowed 10 marks.
53 None appears on behalf of the petitioner at the time of call. Stop. Released on 22nd of December.
54, I am for the petition. Petitioner was appointed as an assistant teacher in the year 2002. While he was appointed, he has already completed his part 1 of master's degree. He applied before the school authorities to give permission to complete the examination. School gave permission on the condition that I will not claim higher pay scale. I have not claimed higher pay scale. Thereafter, I completed, I rejoined. Thereafter, board, my lord, confirm that leave as half average pay leave or from commuted leave, it has to be adjusted. My lord, subsequently, when I completed 10 years of service, I applied. I was granted 10 years of service from the date of joining. But my lord, at the time of applying for 18 years service,
The authorities told me there is, since you were absent for 170 days without pay leave, that 170 days are to be deducted from your service, and if you don't pay the excess amount overdrawn, we will not grant you 18 years benefit. My lord, under compulsion, I gave the amount and I was granted 18 years of service, belatedly deducting 170 days. And subsequently, my lord, 20 years service, same thing. I am challenging, firstly, the overdrawn amount, my lord. It is not because of my mistake, so it cannot be recovered from me. Secondly, my lord, that 170 days cannot be deducted. I have filed a representation before the authorities. The same is still pending.
You want consideration of your representation?
My lord, for the time being, the
For the
authorities
time
has
being, very well. Which page?
my lord, page, my lord, 57.
But I appear for this school.
I'm for the
Supporting the petitioner? No.
Well, once he has accepted and he has refunded the amount by filing a challan,
Very
how
well. The
he can come to the High
representation,
Court and says,
the representation is before the DI, not before you. So let the DI consider.
very well,
Please come.
we're giving hearing to all the parties.
Please come. The petitioner has approached the District Inspector of Schools, Secondary Education, Jhargram, with a prayer for reconsideration of the financial benefits received by her.
Him, my lord, him.
Acha, him. On completion of 10, 18 and 20 years of service. Step paragraph.
My lord, the period of 10 years, 18 years, and 20 years. sir.
Yes. The as it appears that the representation is pending consideration before the DI, accordingly the court directs the DI to consider and dispose of the petitioner's representation strictly in accordance with law at the earliest.
when the money was refunded in
But
2012.
positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter.
My lord, after giving opportunity to all the interested parties.
Let opportunity of hearing be granted to the petitioner and all other necessary parties prior to passing a final order in the matter.
My lord, may I just submit my report?
Report of the whose report?
It's DI's report, my lord.
District Inspector of Schools, Secondary Education, Jhargram. Dated 27th November 2025. Be written with the records. You have a copy?
Lordship,
Yeah,
Do you have a copy?
I've already given a copy to them, my lord.
আমি তোমাকে দিয়ে দিচ্ছি
আচ্ছা ঠিক আছে
Make a photocopy and take it.
আমি দিয়ে দিলাম
গ্রেট
Grateful, my lord.
I am with the petition. Pursuant to your lordship last direction, my lord, serve the notice upon the state respondent.
Who is appearing?
Mr. Arun Raj Tiwari.
What is to be done? What is the order in Sanjay Mandal?
Matters related to the higher scale of pay, my lord. The petitioner, my lord, after taking the permission from the managing committee, he completed the MSc. As per the, my lord, the judgment delivered by your lordships, my lord, covered by this judgment. In this judgment, the petitioner only made application to the managing committee. But in my case, my lord, petitioner managing committee approved the permission, granted the permission. Also, my lord, the managing committee forwarded the application to the DI for prior permission.
The managing committee applied before the DI for permission.
Yes, ma'am.
And the DI did not. Is there any rejection?
Yes, ma'am. Page 47.
Then this has to be decided.
prior permission.
See, in the absence of the state, it cannot be done. None appears on behalf of the state. Despite notice.
Tomorrow, my lord.
Stop. The reasoned order passed by the District Inspector of Schools, Secondary Education, Purva Bardhaman.
Yes, ma'am.
Dated 31st December 2024. rejecting the prayer of the petitioner for grant of higher scale of pay is impugned in the instant writ petition. Stop. The respondents are directed to file an affidavit in opposition. Do you appear for the state?
Yes.
There is one notice served upon Mr. Varun Raj Tiwari. None is appearing for the state. You please see so that somebody appears.
Speak to the necessary.
In this matter, Your Ladyship?
This matter. Bullam. Affidavit in opposition within 9th January 2026. Reply, if any, be filed within a fortnight thereafter. Liberty to mention the matter for hearing on completion of the aforesaid time period. See, the state is not here. Not very difficult.
Tomorrow I will inform Malak.
No, but then since a reasoned order is there, an affidavit should come. Next.
The commissioner in 56.
Yes.
For the state authority, led by Mr. Ansar Mandal, Your Lordship.
Private schools.
Private schools, man. In fact, here also,
Yes.
I have challenged that rules.
You've
Because-
challenged the rules.
Because it excludes me.
Yes. Tomorrow I'll take up.
Please.
All right, only not today.
But even I'm for the petition, but
Report your that.
I'm praying for 7 days accommodation, but I could not prepare myself.
All right. On the prayer of the learned advocate representing the petitioner to come prepared, release the matter on 5th January 2026. Yes. Next.
58, I'm for the petitioner.
I'm for commissioner.
This is for getting 10 marks for prior teaching experience. Petitioner was a teacher in Kendriya Vidyalaya, my lord. On the last occasion, my lord, submission was made by the West Bengal Central School Service Commission that regarding the Kendriya Vidyalaya or the schools which runs under the central government, my lord, they are rejecting their prayers. And since it was not against a substantive post, well, I have made party to the school also, my lord. And another occasion, another thing which was objected before your lordship, my lord, the tenure of service, because I submitted in central school, my lord, the contractual post holds for 11 months, then it renews. This way, this continues 11 months, 7 months, 11 months. This way, I have annexed the certificate also.
Are you challenging the rule also?
No. I'm seeking my seeking marks for prior teaching experience. I worked at Kendriya Vidyalaya Garden Reach.
See, in the rule, there is no provision for awarding marks to Kendriya Vidyalaya teachers. Despite noticing that, you are not challenging the rule.
My lord, what happened, my lord? Before the division bench in Odunima Pulse matter, my lord, first time the board, the West Bengal Central School Service Commission came with a submission that they will award marks to Kendriya Vidyalaya also. I have the order with me, paragraph 24. So, my last occasion when this matter was taken up by your lordship, my lord, the School Service Commission said that they are rejecting the prayer of awarding 10 marks to the central schools, my lord. But I have come up with a supplementary affidavit showing that pursuant to this honorable court order, my lord, 10 marks has been awarded to similarly placed candidates, and he has been placed in the verification list also. She has been placed in the verification list also.
All right, you want to file supplementary?
Yes, ma'am.
Prepare supplementary.
I have prepared already.
Oh, you have prepared already.
I have annexed the writ petition. I have annexed the order. They called for verification. They challenged this order before the division bench. Division bench dictated in the same line. They called and they awarded the marks. But prayer was made for consideration only. In this writ petition also, for consideration. Page 65 is the order.
What is the final order that has been passed by the secretary?
My lord, they called for, she has been called for verification. That is annexed at page 69. The last one, Shisha Ghosh. Several orders have been passed in several writ petitions. I can show another instance where your lordship has passed the order and they have been awarded marks. This is the order passed by your lordship.
Show me the order of Arunima Pal,
Yes, my lord.
where the submission of the commission is recorded.
এক্ষুনি দেখালাম।
We have said so in affidavit as well, that we are awarding marks to central government school, to Kendriya Vidyalaya school, to Jawahar Navodaya Vidyalaya school. It is recorded in
24.
admittedly. But my lord,
yes.
But my lord, the teacher has to work against a substantive post and for minimum period of 1 year. My lord, a service, my lord, if it is fragmented, we cannot award marks. My lord, the instance of Shisha Ghosh which has been shown, my lord, the rules do not discriminate between the state government or the central government or other states government school. My lord, we have awarded marks of 10 years to UP government school pursuant to the lordship's order when we have considered. My lord, rules say government sponsored, government aided school. So my lord, Kendriya Vidyalaya is a government school, and my lord, if the teacher concerned has
So
worked
right
for a
now there is no issue with the school where the petitioner is teaching. The issue is with the service tenure.
Tenure, my lord. She has
Alright.
not worked for 1 year.
Where is your tenure?
My lord, my tenure, my lord, in the writ petition, my lord, kindly see the
Page
page
25
30 of
onwards,
supplementary
his
affidavit
experience certificate is
with
there.
regard to Shirsha Ghosh. Page 30
But
of
I will
supplementary
explain
affidavit.
Shirsha Ghosh as well.
They do not have an issue with regard
But
to
I
your
will
Shirsha
explain
Ghosh is
Shirsha
similar.
Ghosh as well.
Shirsha Ghosh is also 11 months. I am also 11 months. My lord, this Calcutta size, this 11 months is the tenure.
But
Thereafter,
that 10 marks has been taken away, my lord. I will explain that. I will place the order of Shirsha Ghosh. My colleague is carrying that order.
my lord, 25
Which
is my
order?
My lord, the order passed by the secretary in Shirsha Ghosh's matter pursuant to. My lord, the 10 marks was given inadvertently. It was removed. Subsequent result was also there. My lord, it is not in the supplementary affidavit. My lord, kindly takes the order of Shirsha Ghosh.
My lord, I can show your lordship another instance where your lordship has passed order and they have been.
Oh, the issue is not with regard to the school where you are teaching. The issue is with your period of service.
Lord, if your lordship has Shirsha Ghosh's order, kindly takes the last paragraph, my lord.
Last paragraph, the prayer is rejected.
Because the
Experience is fragmented.
And
Even by
even
adding
adding
marks,
marks for experience, she falls short of cut-off marks.
No, that is on merits.
No, that is
She falls
different.
short is a different thing.
So
How
she,
much
her
has
experience
this petitioner got? How much did you get? And for how many years are you serving?
1 year, 8 months.
So at best, you can get 2 marks,
2 marks.
not more than that.
2
How much you have scored?
11 and 12, my lord, I secured 43 out of 60.
What is the cutoff in 11-12? Which subject?
Biological science.
What is the cutoff?
Well, cutoff, my lord, I need to check because the result has been published subsequently. This writ petition was filed, my lord. Thereafter, the verification list published. And the
All right, let the commission take instruction. Please come. Supplementary affidavit filed by the petitioner in court today is taken on record. Stop. The order dated 22nd November 2025 passed by the secretary of the commission in respect of the matter being WPA 22321 of 2025 within bracket Shirsha Ghosh versus State of West Bengal and others. Placed by the learned for the commission be also written with the records.
Well, Shirsha's result has also been updated, my lord. Will it be your lordship's pleasure, my lord, to take it on record as well? My lord, we are carrying that result. She was inadvertently awarded 10 marks, my lord. She was amended subsequently after the order was passed.
The result details of Shirsha Ghosh is already taken on record. Not already, is also taken on record. Stop. On the prayer of the petitioner to come prepared. 22nd of December.
My lord, the other instances which he is relying, if you can hand over copy, my lord, we can take instructions on that as well. He's saying in other cases as well, we have given 10 marks. My lord, we have given 10 marks to teachers of other schools, other state government schools, pursuant to your lordship's order, my lord, because they had continuous service
Yes,
in
in Pinto
substantive.
Malik's matter, my lord, they have awarded marks and up.
Give it to your learned friend.
Not 10 marks, 6 marks, 6 marks.
Whatever, at least marks
They
on
were the
account of
teachers of
prior
UP
teaching
government.
experience.
They were the teachers of UP government, Pinto Malik, and they were working in a substantive post appointed by the School Service Commission of UP.
Alright. Next.
Obliged.
Order for the petition. But the petitioner before your lordship, my lord, was engaged in the service in the honors graduate post, my lord. And after that, after taking permission from the school, my lord, he has.
You want higher scale of pay?
Yes, I made the representation after completion. It was forwarded to the district inspector.
Note kept?
Notes left.
Please come.
Page 36.
The petitioner's prayer seeking higher scale of pay
This issue is
was
covered by your
reported
lordship.
by the school authority, and the same is pending consideration before the District Inspector of School Secondary Education, Purulia, for more than a year. Okay, stop. Any instruction?
No, ma'am.
Learned advocate for the state is not ready with proper instruction. Stop. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools Secondary Education, Purulia, to consider the prayer of the petitioner for grant of higher scale of pay, strictly in accordance with the relevant rules and the law laid down by the court from time to time.
My lord.
A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be provided to the petitioner for production of necessary documents in support of his claim,
Including the judgments. Of this one.
including the judgments relied upon by him.
Great.
Yes, a reasoned order shall be passed and communicated to the petitioner immediately thereafter.
Gratefully. Will the affidavit of service be taken on it?
Yes.
For the petition. This is a matter regarding payment of house rent allowance. This issue, the husband of the petitioner is working in a private organization. That is why his HRA has been stopped. This issue has been dealt with in several judgments. I have annexed matter that is at page 91. 2 judgments I have annexed, which was passed relying upon the judgment of Moushumi Vishwas, which dealt with this issue. But 2012, a government notification has been issued, which says the spouses of the government employees who are working in a private organization, they are not entitled to get HRA. Now, thereafter, this scope of this GEO has been extended in case of the teachers also. Subsequently, this issue has been, your lordship, kindly come to first.
Any idea whether the petitioner's spouse is teaching in any government school or employed with any government organization? No? Please come. Where is your prayer?
Well, my prayer is at page 17.
Yes, she has not made any application to the authority.
Not required, because this general notice has been issued by which the HRA of all the employees have been stopped, and that is at page 49A.
The petitioner alleges that her house rent allowance within bracket HRA has been stopped. Has it been stopped completely, or you are getting
Stopped, my lord, from since 2018.
Has been stopped.
That I have stated in paragraph 13.
Paragraph
13 of my writ petition. Since August 2018.
Since August 2018. Full house rent allowance, you say. That means, are you getting part of it?
No. Since 2018, nothing has been paid. I have annexed.
Sure.
Lordship, I have annexed my lord my.
Because there are teachers to whom part payment is being.
Your lordship, kindly come to page 39. My salary statement.
Instruction, lordship, kindly details. Because 2018, they have been stopped. Now he has challenged in 2025.
This is a continuous.
Page 39, you are not getting a.
My lord, kindly come to HRA 0000.
Has been stopped since 2018. August 2018, allegedly because her husband works, her husband receives HRA from his employer. Stop. Specific submission of the petitioner is that her spouse is not engaged with the state government but serves in a private organization. Stop. The HRA received by him should not be taken into calculation for should not be taken should not ought not to be taken into consideration for providing HRA to the petitioner. Stop. Reliance has been placed on the judgment delivered by this court in the matter of in a batch of writ petitions. First of which is WPA 1389 of 2018. In the matter of Moushumi Biswas and another versus State of West Bengal and others. Judgment date on 16th of March 2021, wherein the court laid down that the HRA received by the spouse of the employees employed in private organization cannot be taken into consideration for deciding HRA, not deciding grant of HRA in favor of the teachers of non-government / sponsored educational institutions. Teachers এর জায়গায় লিখুন তো employees. ঠিক আছে, next. The petitioner asserts that her spouse is serving in a private organization. Stop. Next. The learned counsel for the state is not ready with instruction. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools within bracket Secondary Education, Kolkata, to grant an opportunity of hearing to the petitioner for production of documents in support of her claim for a house rent allowance. Stop. If it appears that the spouse of the petitioner is employed with a private organization, then house rent allowance shall be paid in favor of the petitioner. HRA house rent allowance in full shall be paid. Stop. A decision shall be taken by the DI at the earliest but positively within a period of
page 100 once, my lord.
Period of 12 weeks from the date of communication of this order.
Well, last observation of the coordinate bench was that the area should be paid with 6% interest, and that was complied with. That is at
All
page
right.
102.
As the petitioner would receive her HRA at a delayed point of time, the same shall be paid to her with interest at the rate of 5% per annum, calculated on the due amount on and from the due date till the date of actual payment. Next.
Great.
Not today. Why not? Affidavit of third. 62. Keep it with you. 62. 62.
I am for the state. Transfer the teacher, my lord. The teacher, my lord, working the Barnia High School, my lord, in Nodia. My lord, this, my lord, down is, my lord, he has been appointed as MSc Science in the state school, but there is no science.
You have been empaneled in the state.
My lord.
When?
2017.
From 17.
Lord, my lord, there is no, my lord, science teacher. I have been appointed as science teacher in the high school, but there is a science teacher.
What you want?
I want the I may be transferred, my lord, to any suitable school, my lord.
Where is your application?
Lord, application, my lord, I have sent, my lord, through mail, email, and my lord, by post also I have
When?
got a receipt. That, my lord, I have, my lord, given, my lord,
by my advance letter dated also, page 55.
Page 19.
With that, my lord.
To the Commissioner of School Education.
No, school, so mail, my lord. I have stated.
No, not stating. You show me that you filed application in the prescribed format.
Is a format, my lord. I have there, my lord. My advance, I have, my lord, with the not the student. I have format. I have annexed the format. My lord, that, my lord. I have, my lord. I have stated that the format. Format is, my lord. Format is, my lord. My lord, page 20 is the format. And I arrange the format, my lord. That will show, my lord. My lord, page 58, my lord.
My instruction has come.
Please give. Page 58 is the Gazette notification I can see.
No, please.
Performa is, my lord, page 20.
Lord, page page 20.
No, where did you submit it before the school?
Lord, school I have submitted through mail.
Oh, there is a no objection from the school also, page 23.
Yes, sir.
Then you said that he did not submit.
He submitted before the school, but it is directly forwarded to the Commissioner of School Education. The duty of the school is to
Who
forward.
forwarded to the Commissioner of School Education?
Petitioner himself.
No, that is his request. He can forward it to the President of India also. How does it matter? The school has issued a no objection certificate. Please come. Who are you for?
DA has given the instruction.
What is the instruction say?
Not considered.
Not considered means?
Transfer not considered.
What is not consideration?
There is no post.
Acha, likhun to. The petitioner's application seeking transfer made in the prescribed format was forwarded by the school to the District Inspector of Schools, Secondary Education, Noida. Stop. The same has not been considered on the ground of suspension of the Uchshosri portal. ঠিক আছে এবার আমাদের যেটা আছে না সেইটাকে করে দেবেন instruction forwarded by the DI written with the records disposed. Followed? What?
May I serve the copy?
If. Next.
You're not time for the petition.
Yes.
Lord, here the managing committee of the school is the petitioner before your lordship, represented by Lord the person in interested. Lord, the complaint filed against a particular teacher from 2023 to 2025 before the 2013 to 2025 last 12 years before the DI, before the Lord the board against her misconduct.
You didn't serve copy
Yes.
on the board?
This is my service.
When was it served?
But I have to check it.
You should have checked it. Where is the service on the board? The state has been served. The DI, the assistant teacher in charge. Where is the service on board? Give a copy. Affidavit of service filed in court today is taken on record. Stop. Copy of the writ petition has not been served upon the West Bengal Board of Secondary Education. Stop. Let a copy of the writ petition be served upon Ms. Koili Bhattacharya, learned advocate, who is present in court and who usually represents the board before the court. Stop. Release the matter for further consideration on 5th January 2026.
Phone number.
Sure, my lord, I am for the petitioner, my lord. My lord, the service is not completed, my lord, still.
Hearing for the commission in this matter.
Service is not complete. The commission is present.
Yes, sir. This,
See?
my affidavit service is not complete.
All right, affidavit of service is
Yes.
not ready. What is the matter?
My lord, I am the candidate of assistant teacher in higher secondary school. At first time, I was a successful candidate in 12 SLST, first SLST, RLST 12, and I was appointed in 2013. Thereafter, I for my benefit, I again appear on the first SLST 2016, which panel has been already cancelled.
What is your prayer? Please tell me.
My lord, my prayer is that I am at present, I was discharging my duty as assistant headmaster. It is purely a separate recruitment process. Therefore, my service could not be reverted back to the earlier earlier service. But I have been issued
Did you apply?
Yes,
For
yes. Yes, my lord. I have.
repatriation to your earlier place?
Yes, my lord. I have. No. I did not apply.
Then?
In person to Supreme Court order, state has issued me order.
Show me.
Annexure 13. Annexure 13, my lord, page 43.
Appointment to the post of assistant teacher. Yes.
40.
You want to join as headmaster?
No. My lord, at present, I am discharging my duty as assistant headmaster.
At present, you are jobless. You do not have a job.
No, my lord. That is why I come before your lordships.
Yes.
No. 2016, no. 2016, I was selected in the 2016 panel.
Yes.
But thereafter, I appeared in a separate recruitment process, assistant headmaster, for being a assistant headmaster.
Yes.
In 2022.
No, then what you want now?
Therefore, my humble submission before your lordships that I was in 2016 panel, but my present service have been effected from 2022 selection process. Assistant headmaster.
2016 selection process prior to the Supreme Court nullifying the entire selection, you joined 22.
22. No.
Let him say.
Before passing order of Supreme Court.
You joined a new service?
Yes, my lord.
Then what happened? Your service must be secure.
My service should be secure, but they have, in person to the Supreme Court order, they have issued me to join to my prior service.
All right. Are you still working as assistant headmaster?
Yes, I.
Are you working?
Yes, my lord. No, at present I have been issued order to join to the previous service at Kendua, Paschim Mendipur, which I have been appointed in 2013.
Is anybody leading you in this matter? Do you have a senior?
Yes, my lord.
Do you have a senior?
Yes, my lord. No, Gopal Sarkar.
Yes.
No, Gopal Sarkar.
I do not know who your senior is.
Assistant headmaster, he is saying that this is a new recruitment.
Yes.
Not a new recruitment.
Do you want to take assistance of
Yes,
a senior?
yes, my lord. Yes, my lord. Kindly fix it tomorrow.
Tomorrow?
1 week adjournment.
Only not today?
1 week adjournment.
1 week?
1 week.
And in the meantime, if page 43 annexure P3,
yes,
time to join has expired, then I do not know what is going to happen. The risk is yours.
No, my lord.
What no?
Tomorrow, kindly.
It has already been expired, my lord.
Yes, I see it. It's already expired. November. In 15 days is supposed to join. Right. So
at present, I have joined. Perhaps I have to take instruction from my client.
Take instruction also.
Perhaps I have joined, but my grievance is why I have been
treated as a headmaster and not as an assistant.
Yes,
teacher.
my lord. Right. Assistant headmaster.
There is a representation. Do you want that to be considered?
No, my representation was not considered. That is why I come before.
You want that to be considered?
Yes, my lord.
Only that?
Yes, my lord. In the meantime, stay of the operation of the.
You have joined, you said.
what I have to do. I could not understand what I have to do because
You are
all
the
of,
learned advocate.
it is my livelihood.
To guide your client as to what is to be done. You say what your prayer is.
Yes, that is
What? Not today?
that should be not
What?
today only not today. My lord, kindly.
One thing, Milord. But his seniority will be protected in terms of Supreme Court order only. It is there in the order. If he is promoted in the meantime, he'll have the seniority as well.
Are you aware whether he has joining?
promoted.
Possibly you will not know, but then he says that he was serving as assistant teacher or something.
He was promoted in service promotion he received in 2022. So
All right.
if the initial service goes, his entire service goes, but his new service in his seniority will be protected as per the paragraph 47 of the Supreme Court order.
Was he there? Was he there in service earlier?
He was there in the service in 2013. Then in
All right.
2016, he was appointed again pursuant to the first SLST. Then during his service, pursuant to first SLST, he was promoted to the post of assistant headmaster in 2022 by the DI, and he was working as an assistant headmaster when his service was terminated. Initial service was terminated. Now, Milord, when he is reinstated in the previous service, he will have the seniority
Yes,
of the
all seniority and all benefits will be given.
Yes,
that the Supreme Court has already is the petitioner entitled to all those benefits?
If he claims for those benefits, then he can make out his case. He currently
All
is
right,
seeking,
you also go through the brief and see what is there, because the petitioner is unable to explain
he
his
has
case.
not claimed that, Milord. He wants to be in the old school only.
That is impossible. I do not know. Yes, where is the petitioner?
65,
Yes.
my lord.
What is it?
Matter relating to overdrawal, my lord. Employee concerned has died in harness, and a widow has come up before your lordship. 65. What? My lord. What do I deducted from PPO, my lord? Deducted from PPO.
Where from will it be deducted? Where from will it be deducted?
No, my lord. In others matters, sometimes has been claimed, and with challan.
With challan, it is after retirement. The person died in harness.
Yes.
How will the authority get to know that the person will die tomorrow? Will the authority get to know?
No, my lord.
Then?
My lord, similar identical matter, your lordship was fixed, my lord, kindly fixed it. 52 as item number 52, Mr.
When?
Oro Mitra. January, my lord.
January? Unlike January. The spouse of the petitioner was serving as a teacher. Stop. He died in harness on 26th April 2022. Stop. Certain amount has been deducted from the terminal dues on the ground of overdrawal payment made to the employee. Stop. The widow challenges such deduction. Stop. Paragraph. The instruction forwarded by the District Inspector of School Secondary Education Noida dated 26th November 2025 be written with the records. Stop. On the prayer of the petitioner to come prepared, release the matter for further consideration in the monthly list of January 2026. Do not call any other matter.
Okay.